except say for 1 day. That's oh, today. Yeah, around the video. Just can away away. Yeah, you on it. You didn't know. Siapa orang? सब ठीक है ना?
Yes, Your Lordship. Lordship, I'd like to mention item 44.
Item number
44, 44.
yes.
Yes, Lordship, this matter pertains to Colonel Skilla Bay to contingency employee. This matter pertains to Granite Scala Bay to a contingency employee. Contingency pay. Now the matter is at the hearing stage, but I'd like to bring it to your notice that state has filed a special leave petition before the Honorable Apex Court by way of SLB 25185/2023. In view of that, since the media has to be disposed of by the Honorable Apex Court, we expect at the early stage. That's why I pray before your lordship to grant us 4 weeks time. I'm representing all the state sponsors here.
At the request of Mr. So-and-so, the legal counsel appearing on behalf of the respondent, that is stands adjourned to be listed after 4 weeks.
Lordship, I think to mention, I think hearing item 46 to 65.
Why?
Lordship, this afternoon I have a part heard matter through receipt. So Your Lordship, this matter may be taken up on this Thursday, 22nd of February.
Let us hear what is the matter about. I may not require your assistance. First, Mr. Joshua has to satisfy this court as to whether he has a case. And
But
see,
Your Lordship, I have a part heard matter.
don't worry.
Okay.
Lordship. Your Lordship, I'd like to mention item number 27. Your Lordship, here, the counsel for respondent number 4 has a leave of absence. Hence, it may be listed after a week.
27.
Yes, Your Lordship.
Who is this?
He'll
For a
be assistant.
respondent?
Yes, Your Lordship. Private respondent.
When?
Next week, Your Lordship.
Request the counsel for the respondent matter stands adjourned to be listed on 26th. Yes.
May I please, Your Lordship, my Lord, I beg to mention hearing item number 22 to 24. Here, I sought some clarification from the department with regard to the affidavit in reply filed by the petitioner. So kindly allow me 2 weeks time.
We'll see when the matter reaches. Yes.
Please, Lordship. Please, Lordship. As per the direction of this court by order dated 15/11/22, is directed to file an affidavit. I prepared the affidavit and sent for approval to.
We'll see when the matter reaches. It's a hearing matter.
Lordship.
For admission, item number.
So Lordship, Your Lordship, I beg to mention hearing item number 34 to 42. I release this matter after 2 weeks since my senior is in bereavement.
We'll see when the matter reaches.
For admission, item numbers 1 and 2.
Lordship, kindly grant us 2 weeks time to file a reply.
What is this matter about?
Lordship, it's a land compensation measure.
You are for the petitioner?
Please, Your Lordship, on the petition.
Then yes, what are you challenging?
Your Lordship, the respondents have been in occupation of our land without compensation.
Use of its land by RMC. What is that?
Your Lordship, it's the Rangapahar military cantonment.
Then you want fair end.
Yes, we want compensation for the land.
Compensation means this land has been taken by on requisition. Yes, Mr. Iralu?
Your Lordship, in 1966,
Hmm.
this land, the present of 1,235 acres of land was given to the army cantonment by the then DC of Kohima.
Hmm.
And in that 100 acres of land was said to be within this Taibu petitioner village land. That is for there is cultivation. So including that one, altogether area was 1,235. Now, as per the petition itself, on one side the boundary is with Taipu, which means including that 100 it is Taipu, and the rest is outside Taipu village. The rest is outside Taipu village. Now subsequently they claim that even this 1, 2, 3, all of the area belongs to Taipu village. Yes. And now they are claiming compensation for that. Whereas their own document speaks that they have also received compensation.
They've already received compensation.
That is what their document say. The other thing is that they have not given their village boundary. There is no village without having a boundary. Not a single village without having a specific boundary. Now, in this case, no boundary is being given. And so, in fact, this petition is not maintainable.
But whether the land of the petitioner was taken on requisition, because once a
That
requisition
was-
is made
that was-
under the 65 Act, it has to be have some boundaries.
No, because that was a block of land was given to the Taipu village
Hmm.
by the then DC
Okay.
for cultivation. Now in 66, when the 100 acres of Taipu village land was taken, only a few portion was cultivated. The rest was not cultivated. And that is outside the remaining portion of the land. It is not within Tiger Village land, except that 100. And including the 100 acres, it comes to 1,235. Subsequently, now without giving any boundaries, now they are giving that one. Because at that point of time, the deputy commissioner has given the land with the approval of the government. And since that was vacant, there was no recreation process was followed, in fact. Because the government presumed that it belongs to the government. Government's land.
That's government's land.
Oh, some reports speaks like that, but not all. Some are within cadastral, some are outside.
Mr. Iralu, you are appearing for the respondent number
And for respondent number 9,
8.
9, Chumukitima village.
It is 8. 8.
There are two petitions. So in the first one is 8 and the second one it is 9. But the facts are same. Except in the second one, they have included one notification issued by the Nagaland State SRAA.
Yes, madam.
Your Lordship, we need 3 weeks time to file a reply.
What reply?
Reply to the union.
Union has filed a reply when?
Yes.
Your Lordship, on 25th September 2023.
September.
Yes, Your Lordship.
We are in February. Then Union has filed a reply on 26th of September. Then where is the question of filing a reply now?
Your Lordship, we are waiting documents and we'll be filing a reply.
You can't be waiting for documents in eternity.
Your Lordship, we'll be filing as soon as possible,
When?
within 2 weeks.
This week. If we don't file it this week, we'll take it as if you have nothing to say. This can't go on like this. This was the affidavit filed on 26th of September. Then we have taken time. How many times? We have taken time on 29/1/2024. This means the union will not be filing affidavit in a year. Affidavit in reply not filed. But how many times you have taken?
Your Lordship, we were anticipating another affidavit in the second.
You are anticipating somebody else will file an affidavit,
Lordship,
then you
so-
will file a reply. You file your affidavit this week. We'll have it next week. No further times. We'll have it on when? 27th. File your affidavit and reply in the meantime. The learned counsel for the petitioner seeks for an accommodation for filing the reply to the affidavit in opposition filed by the union. It is seen from the records that the affidavit of the union was filed on 26/9/2023. On the earlier occasions also, the petitioner have sought for time. Taking into account the above, this court fixes the matter on 27th of February 2024. In the meantime, the petitioner would be at liberty to file their reply by 26th.
Item number 3 for admission.
Yes, who is appearing for the union?
May I please, Your Lordship, and for the state, Your Lordship, for respondent number 3.
The union is not there, we dismiss it for default. Union's reputation, isn't it? None appears on behalf of the of India on call. What is it challenging? Wash the order date to demand passed with the respondent. 2014. Where is that order? Where is the impugned order? Yes, who is appearing for the union?
My lord,
Yes, where is the impugned order?
viewing order is page 77. My lord, here I am aggrieved by the rate of land that has been fixed by the deputy commissioner.
Yes,
My lord, the state has fixed the rent at a rate of rupees 200 per acre. But here the deputy commissioner, while passing the impugned order, has fixed the rate at rupees 900 per square feet.
not square feet per ton,
I mean,
900
yes,
per
yes.
1,000 square feet.
My lord, sorry.
Then,
Yes.
so what is wrong?
For that I'm aggrieved.
Why?
Because the state government has fixed the rate at rupees 200 per square feet. 200 per acre.
Where?
My lord, that is in my lord, in my IA, that is in page 47.
Yes.
Page
Yes.
47. The second para, my lord. And whereas the governor of Nagaland is pleased to reiterate this department earlier order alarm number so and so dated 29/8/89 to charge rupees 200 per acre per annum. That was the order.
This was done in the year 2006. We are now in 2024. Then,
The state government is to fix the rate.
Ah.
Now here in this particular case, the deputy commissioner himself has fixed the rate. Now wherein the deputy commissioner has no authority to fix the rate of land.
why?
Because my lord,
This is done under what provision? How are you getting the land? The land is being given to you under what?
on lease.
On
I've taken-
lease.
Yes, on lease.
Who is giving you the lease?
Any buyer. Any buyer has given me the land on lease.
No, no. Who has given you the land on lease? Who has given you the land on lease?
The government.
Show me that. Where is the government has given you the land on lease?
It was the government through any buyer. Any para is the landowner.
This is the lease deed, page 41.
I don't lease for page 25
Of the,
of the deed. It has been executed on 25th September 1984. At a rate of ₹50.
this was given in 1984.
My lord. It was executed.
Now the government have not revised the rate. The government revised the rate in 2006,
Yes.
making it 200 rupees per acre.
200 rupees.
So you say that you are, now has the
Yes.
government revised the rate thereafter, madam?
Your Lordship, in this regard, Your Lordship, I have not received an instruction, Your Lordship. And even the IA, I am very much unknown to the IA that has been filed. Even this writ petition, I got it in the middle of the, like somewhere in July like that, Your Lordship, the service copy. So Your Lordship, now IA is also new to me, Your Lordship. I don't know what is the
IA
interlocutory
is-
application.
So
That has
your
not been served to me.
Your basic case is that in the year 1984, there was a lease agreement entered into for a period of 50 years. And of these 50 years, at that point of time, it was 60 rupees per acre and subject to revision of the rate by the government from
By
time to
law,
time.
Yes.
Now, the government have revised the rate in 2006 to make it 200 rupees per acre.
My lord.
How, therefore, the deputy commissioner could not have made it 900 rupees per 1,000 square feet.
Exactly,
That's your case.
my lord.
So we need only one instruction as to whether there has been a revision by the government.
Exactly.
And if it is no revision done,
Yes.
then you are to only pay 200.
Yes, and the 200 I've been paying.
Yes, madam.
Your Lordship, I may need some time, Your Lordship, to.
Okay.
Your
We'll have
Lordship,
it
I
Friday?
don't, Your Lordship,
Friday?
that may not be
Only
possible.
thing, instruction, I don't require anything else. Only one instruction. Have the government pursuant to that fixing of 200 rupees per acre in the IA.
I have not received even the IA, Your Lordship.
Okay, don't worry. You have a copy of the IA?
My lord, yes.
Yeah, give it to her.
My
Not so.
lord, this I has been disposed.
Anyway, give a copy to her.
Fine, fine, fine.
Because she, you see, yeah, you give a copy to that I, you have it with you now,
My lord,
give it to her. Now,
it's a bit bulky.
it's okay. You don't need to
Yeah, yes,
photocopy
yes.
it, just give it to her now. Yes. Madam, kindly come to page 47. I need only one instruction, I don't need much. Page 47. Yes, before that, kindly come to page 41.
Yes, Your Lordship.
Down below, this is the agreement entered into
Yes, Your Lordship.
for a period of 50
Yes,
years.
that I know.
Okay, down, it is hereby agreed in page 41. The lease shall commence on the first day of November and shall, subject to the terms thereof, continue for a period of 50 years, determinable nevertheless as hereinafter provided, the lessee so ends paying therefore rent at ₹60 per acre per annum till the rate is revised by the government of Nagaland, and at appropriate revised rates from there onwards payable after expiry of each year, with an option to the lessee to renew the lease for a further term of first of so and so. So here it makes it very clear that it is the government who will, initially it is 60 rupees and subject to revision made by the government. Now kindly come to page 47.
Yes, Your Lordship.
This is the notification where the government fixed it at 200 rupees per acre.
Yes, Your Lordship.
So therefore, Now, the deputy commissioner, what the deputy commissioner has done by the impugned order, made it 900 rupees till 2005 per 1,000 square feet, which is not an acre. And thereafter, more than that. Now, the question arises out here is to whether there is any other government notification after this. I don't require anything else.
After this 12 January 2006.
Yes, that's only. That would suffice. You don't require to file any affidavit, nothing. Only this.
Lordship,
Yes.
Your Lordship,
Friday?
no problem, Your Lordship, provided that the respondent number one, the respondent are also available, Your Lordship. Because,
Respondent, I'm not asking. I'm only asking you.
yes, Your Lordship,
As
that,
to whether the government have increased the rate.
yes, to that extent, Your Lordship.
Only that.
I'll bring an instruction
Nothing
to
more
that
than that.
extent.
I don't require your affidavit, nothing. Only thing is that, is there any other notification after 12/1/2006? And if what are the notification and if what is the rate? That's all.
Lordship, to that extent, I'm bringing instruction.
That's all. So and so the learned counsel appearing on behalf of the state respondent shall apprise this court on 23/2/2023 as to whether there is any other notification issued by the government of Nagaland Land Revenue Department after 12/1/2006, thereby fixing the rate of the land rate, the rent rate, thereby fixing the rental charge per acre, per annum. List according. That's all, madam.
For admission, item number 4.
Further to that, Ms. So-and-so shall also apprise this court as to whether the rent in respect to the lease agreement can be increased by the deputy commissioner.
Your Lordship, if this order can be furnished in the day, course of the day, Your Lordship, so that like
Yes,
immediate
you-
instruction can be obtained.
Don't worry, the order will be there at 1 o'clock.
Oh, Your Lordship.
Yes. Yes, yes, madam.
Yeah, please, Lordship.
Ah,
Lordship, here I'm appearing on behalf of respondent number 7.
yes. What is the matter about?
Lordship, here I'm yet to find my affidavit in the position, Lordship.
When did you appear?
Lordship. I'm appearing on behalf of counsel for.
When did you first
respondent
appear
number 7,
before
Lordship.
this court, Mr.
Lordship,
Counsel? When
I'm
did you,
appearing on
when
behalf
did
of-
you first appear before this court?
Lordship, last date, Lordship.
Earlier you did not.
Yes,
Respond
Lordship.
number 7 appeared only on last date.
Recently, Lordship.
When?
30th January, Your Lordship.
Wakalatnama filed on 13/11/2023.
Lordship, kindly one week may be granted, Lordship.
Okay. The counsel appearing on behalf of the respondent number 7 seeks for an accommodation. Oh, earlier also you have taken time.
Yes, Lordship.
When? This is subject to cost.
No, Lordship.
She has to come all the way.
I'm appearing on behalf of counsel for
10,000?
the respondent number 7, Lordship.
10,000? She had to come all the way today. 10,000 cost.
Lordship, I'm appearing on behalf of counsel for the respondent number
what?
7.
Then we will consider none has appeared on behalf of the respondent number 7. If the
Lordship,
counsel is not there,
I was informed that he was engaged recently, Lordship.
so can't help it. Impose
Lordship.
cost of 10,000.
Kindly one week may be
Yeah.
granted, Lordship.
At the request of the learned counsel for the respondent number 7, matters stand adjourned to be listed again on 29th of February 2024. In the meantime, the respondent number 7 is given a final opportunity to file their reply on or before 28/2/2024.
Compliant, Lordship.
My lord, here I beg to mention that my name Z Jimomi is not here in the case. I'm not engaged, but I've been seeing my name for some time, so kindly delete my name, Z Jimomi.
Judge Zimomi, the learned counsel, submits that her name has been inadvertently shown in the cause list. Her name should be removed. The registry shall take due note of it and do the needful.
Obliged.
Lordship, it should be H. Jimomi.
Who's?
Instead of Z, it should be H. Jimomi. H. That is the written mistake made by the registry.
So Ms. J. Zimomi, the learned counsel, submits that her name has been wrongly shown in the cause list. She further submits that instead of her name being shown, the name ought to have been shown by the registry is H. Zimomi. The registry shall do the needful.
Right now.
For admission, item number 5.
Yes.
Please, Your Lordship. Lordship, the petitioners are employees of the Nagaland Consumer Commission, Lordship. They have been appointed, many of them have been appointed more than 10 years back, Lordship. They've been in service for more than 10 years. There was no post creation initially, Lordship. Somebody had to man the work in the commission. After years of their services, Lordship, they have become a part of the commission that is indispensable of the services that is required, if I may, Lordship. Now, Lordship, after using the service for more than 10 years, they are all still on fixed pay. My Lord will kindly appreciate that according to the Bagla report, now every state has to create posts, Lordship. Even the state of Sikkim, which is the commission, the number of workload is even lesser than Nagaland, Lordship. They have 15 posts created. As far as Nagaland is concerned, not even a single regular post has been created till date, Lordship.
This is in respect to
The Nagaland Consumer Commission.
consumer.
Yes, Lordship.
And in view of the new act which has come in, what is the effect of the 2019 Act? 2019 or 2021? New Act, Consumer Protection Act?
19, Lordship.
19? What is the effect thereafter? Isn't it statutorily mandated to have these posts?
Lordship, the state has not taken any step thus far. And even the affidavit of the state also, if my Lord goes through it, just skirting around the bush, not necessarily coming into the issue and reproducing the judgment in the Uma Devi 3 judgment, Lordship. If my Lord may kindly appreciate, after the Uma Devi judgment, several judgments have been pronounced. The UP Electricity Board also, where Uma Devi judgment is not to be mechanically applied. Then the 2019 judgment of Tiwari, Lordship.
Now, thereafter, you have the judgment of the district, the state of JNK versus district bar association, Bandipora. So that judgment also, it's a judgment by 3 judges, wherein it is held that Uma Devi has to be followed. It is a different thing. 226 power cannot be exercised for the purpose of directing regularization. That law is settled. But the question is, if it is statutorily mandated, and if they are not doing it, then in that case, how does Uma Devi come into the place?
Lordship, that is the state's
This court is not going to go for directing them to regularize you people, no. But the question of creation of the jobs or posts will be relevant.
That is also their, Lordship, but my Lord may kindly appreciate this. Most of them are now of age, more than 10 years in service. And if you go by the Tiwari judgment of 2019, Lordship, now when the state at their own whims and fancies are continuing to appoint, Lordship, regardless of the direction that is in the judgment of Uma Devi, Lordship, the 2006 to be the date for regularization of accounting 10 years, Lordship, 2006. Lordship.
No, but Uma Devi, I think you are referring to paragraph 53.
Yes, Lordship.
Wherein the Supreme Court says that those people who have been working without any orders from the court and so, they can be done so. But if there is any regularization orders which have been already passed, you see what has happened, there were a lot of high courts which were passing directions for regularization. Therefore, the question came up before the Constitution bench that how can there be a question of regularization passed under 226? Because of the fact that the moment this court directs regularization, you will be in fact directing an appointment into a cadre of the post or cadre of the services without the due process. Isn't it? So
Lordship,
that is the problem which arises.
The other issue is also, Lordship, they're still on fixed pay, Lordship. Even their services are, at least the minimum pay scale should have been granted to them, Lordship. That is also there.
But minimum scale of pay, which we are saying on the basis of Jagjeet Singh, That has to be on the basis of there are contemporary posts which are there, wherein these
Yes,
people are
Lordship.
getting
In
the
other
same
departments,
post.
Lordship, yes. Same post, Lordship, in fact.
But that is not your prayer here.
Yes, Lordship, but it is part of my pleadings, but inadvertently that is not part of the prayer, Lordship.
That is a completely different aspect.
My lord.
Anyways, see. Now you check out as to whether it is required to have post,
My lord.
creation of post. Then we can take it up on the basis thereof. If it
Lordship.
is required,
As
not
per the
as
Act of- yes, Lord.
statutorily, that these are the infrastructure which is required. Now, the Consumer Protection Act is there, new one, and the
Well,
rules have been framed most probably. And in those rules, whether it is required or not, if it is required out there, this court will obviously direct them
Let
to
me have a
creation.
look, Lordship.
Because they have to, then it becomes mandate on the basis of the law laid down. And
Bagla
once the
report I have already
constitution,
enclosed, Lordship, but the Act of 2019, I'll have to go through it, Lordship.
You go through that and then the rules.
My lord.
So then we take it up.
Lordship.
When?
Then my lord, may kindly grant me 2 weeks.
Okay.
My lord.
The request of the learned counsel for the petitioner, Mr. So-and-so, matter stands adjourned to be listed on when? 4th of March?
Fourth, Lordship, I have a matter before the principal bench.
When? 8th of March?
My lord.
8th of March.
7th, Lordship.
7th of March.
Oblige, your Lordship.
For admission, item number 6.
Please, my lord, lordship, affidavit in reply to the affidavit in opposition is ready. The petitioner is unreachable for 2 days, so I'll be filing, I'm waiting for his signature. I'll be filing within 3 days, lordship.
It's that the nominee appearing on behalf of the petitioner submits the affidavit in reply to be filed against the affidavit in opposition is ready and will be filed within a period of 3 days. This the matter again on when?
Next week? Next
week. We'll list the matter again on 27th of 27th
Lordship.
February 2024. In the meantime, the petitioner will file the reply.
Lordship, obliged.
For admission, item number 7.
May I please, my lord? Lordship, in this matter, I'm yet to receive instruction from the department. If 3 weeks' time can kindly be granted to me, your lordship. The matter relates to minimum scale of pay.
Then matter of 2022. The Angami, the learned senior okay, 3 weeks.
Or lordship, if I may be allowed to make a short submission, your lordship. In the petition, they have annexed one the presentation, which is pending disposal, your lordship. Now here also the representation speaks about their prayer is same in the writ petition, seeking for a minimum scale of pay to the department. The representation has been submitted to respondent number 2, the lordship. So if respondent number 3, my apology, your lordship. If lordship feels it deemed, then a direction may be given to the respondent to dispose of this, to consider the representation of the petitioner which was submitted to them and dispose of the writ petition accordingly, my lord.
Mr. Counsel, I don't do that. I would definitely do that first, stating that he is entitled to and then direct. If you want that direction, I can do that. That he is entitled to the minimum scale of pay, being he in the temporary area, but of those persons he is entitled to, but I can't direct them to. So I'll say that on the basis of whatever I have held, you now take up the consideration for the representation. You want that?
Lordship, then in that case, sometime may be kindly granted to me so that I can get the necessary.
But this will be
instructions.
subject to cost. How many times you have taken adjournment?
Lordship, I have already sent reminders to them.
So they are not bothered. So if
Lordship-
they are not bothered, so how many times the adjournments have been taken?
Lordship, I understand. What happened is, your lordship, there are some few matters on the same subject matter pending before the
appellate court, which my learned friend has mentioned, item number 45. This also relates to the minimum scale of pay. Maybe this is the reasons why, and this is the reason why probably.
You are
the-
saying about the matter which Mr. Muajami had
Correct,
mentioned.
correct, Your Lordship.
So that was the matter pertaining to what?
Minimum scale of pay, Your Lordship.
So,
And this is also exactly the minimum scale of pay, Your Lordship.
so then
However, in this matter, I'm yet to find my
the
affidavit.
state has filed an appeal. Has there been a stay to the order?
That maybe not, Your Lordship.
So if there is no stay, obviously I'm bound by the
Yes.
division bench order. Where's the division bench order?
Lordship.
Which you are assailing? Will pass an order on a similar terms that he is entitled to go and file an appeal.
In that case, Your Lordship, a short debt may be.
Because you see, our division bench has also passed, means in the principal seat also in Assam, it's the same thing being followed on the basis of Jagjit Singh.
Correct.
That if he is working for a period of 10 years, he will be entitled to.
Correct.
So,
A short.
do you know the reason why this is being done? Because you are not supposed to have a person in ad hoc service for 10 years.
Yes.
You are, because the ad hoc service is only for a temporary measure, 1,
Correct.
2 months, 6 months, 8 months.
Correct.
But if you are having a person for 10 years,
Correct.
obviously, therefore, he is entitled to. Chalo, let me. What are your prayers? Minimum scale of pay.
As per latest ROP.
Huh?
Minimum scale of pay as per latest ROP.
We dispose it of.
Lordship.
The instant writ petition has been filed by the petitioner, seeking a direction upon the respondent authorities for payment of the minimum scale of pay in terms with the latest revision of pay adopted from time to time with areas thereon. From the materials on record, it reveals that the petitioner was appointed on 1/9/2000 to the post of ward charge labor on fixed pay under the establishment of the Executive Engineer PWD R&B Central Division, Twensang, Nagaland. The petitioner, on the basis of his appointment, was being paid an amount of rupees 5,280 per month. It is the specific case of the petitioner that the petitioner is discharging duties as those of the regular grade 4 employees, and hence the petitioner deserves to be treated similarly while granting the benefits as those of the regular grade 4 employees. On the basis of that, the petitioner had submitted a representation on 5/8/2022. To the engineer in chief NPWD, requesting the said authority to grant the minimum scale of pay in terms with the latest ROP as given to the regular employees in his rate. The entire edifice of the case of the petitioner hinges upon the judgment of the Supreme Court in the case of State of Punjab and others versus Jagjit Singh, reported in
2017, Volume 1 SEC.
page
148.
Taking into account that the representation of the petitioner have not been considered, the petitioner has approached this court by filing the present writ petition on 27/10/2022. The record reveals that this court, by an order dated 31/10/2022, had issued notice the respondents, in spite of availing various adjournments, have not filed their affidavit in opposition. Today, Mr. N. Angami, the learned counsel, senior government advocate, had submitted that similarly situated persons like the petitioner have been granted the minimum scale of pay in terms with the judgment in the case of Jagjit Singh by this court, by the division bench of this court. However, an appeal SLP has been preferred before the Supreme Court, being SLP number 35341-42-45-48 of 2023. This court had specifically inquired with the learned counsel appearing on behalf of the respondent as to whether you have the Jagjit Singh judgment, as to whether the Supreme Court had stayed the judgment of the division bench of this court. Stay.
No, Lordship, as far as my knowledge goes, no.
The learned senior government advocate, with all fairness, submits that as far as his knowledge goes, there is no stay to the said judgment. In fact, you can very well find out also, na?
Lordship.
You found out, no. Try to find out, no. On the above backdrop, this court have heard the learned counsels appearing on behalf of the petitioner, as well as the counsels appearing, as well as the respondent, and have given the due consideration, have given an anxious consideration to the contentions so forwarded. The Supreme Court, in the case of State of Punjab, in the case of Jagjit Singh Supra, had observed Supra, while dealing with the claim of the temporary employees, had observed that the principle of equal pay for equal work has to be extended to the temporary employees, bracket, differently described as work charge, comma, daily wage, comma, casual, comma, ad hoc, comma, contractual, and the like. It was further observed that an employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities, and certainly not in a welfare state. It was categorically observed that such an action, besides being demeaning, strikes at the very foundation of human dignity. It was also observed, taking into account the facts involved therein, that there was no room for any doubt that the duties and responsibilities discharged by the temporary employees were the same as were being discharged by the regular employees. On the basis thereof, the Supreme Court had categorically observed that all the temporary employees concerned in the best of cases before the Supreme Court would be entitled to draw wages at the minimum of the scale of pay, bracket, at the lowest grade, comma, in the regular pay scale, bracket close, extended to regular employees holding the same post. Paragraph 57, 58, 60 and 61 of the said judgment being relevant is quoted herein below. In the instant case, it is seen that the petitioner claims that he has been appointed as a labor on work charge basis, and he had rendered service for almost 22 years, 23 years as on today. It is the specific case of the petitioner that the petitioner is also discharging duties as those of the regular grade 4 employees. Further to that, it is also the case of the petitioner that the petitioner's qualification is the same that too of regular grade 4 employees. In that view of the matter, this court is of the opinion that the law laid down by the Supreme Court in the case of Jagjit Singh Supra, and more particularly referring to the paragraphs above quoted, would apply to the facts of the instant case. This court have also taken note of that the petitioner herein claims that he has been discharging same duties that of the regular employees, grade floor employees. As well as also that the petitioner has the same qualification to that of the grade 4 employees. If that be so, the petitioner, in the opinion of this court, would be entitled to the minimum scale of pay minimum of the pay scale bracket at the lowest grade in the regular pay scale extended to the regular employees holding the same post. This court cannot also be unmindful of the fact that in spite of notice being issued to the respondents have not cared to file their affidavit in opposition, denying to their averments as to whether dealing with the averments made in the writ petition as to whether, more particularly as to whether the petitioner is rendering similar service to that of the regular employees, and as to whether the petitioner's qualification is one and the same to that of regular grade 4 employees. This court, however, is not inclined to pass at this stage directions for granting the petitioner the benefit, to grant the petitioner the minimum of the pay scale bracket at the lowest grade in the regular pay scale on the ground of doctrine of non-traverse. This court have duly taken note of that there is a representation so submitted by the petitioner on 5/8/2022. This court, therefore, disposes of the instant writ petition with a direction to the respondent authorities, and more particularly the respondent number 2 and 3. Respondent number 2 or 3? 2 and 3. 2 and 3. To consider the representation of the petitioner on the basis of the observations made herein above, and more particularly to the paragraphs quoted of Jagjit Singh Supra, and the said respondent authorities, if is of the opinion that the petitioner herein performed, discharges similar work with the grade 4 employees and also has the similar qualification, the petitioner would be entitled to the minimum of the scale of pay. Would be a minimum of the pay scale bracket at the lowest grade in the regular pay scale, extended to the regular employees holding the same post. The said exercise be completed within a period of 4 weeks, 6 weeks?
Yes.
6 weeks from the date a certified copy of this order is served upon the respondent number 3.
Deeply obliged.
For admission, item numbers 8 to 20.
Lordship.
Yes.
Lordship, here I'm paying for the petitioner in the item 14 to 20, Lordship. Lordship, pleadings are completed. Lordship, if
What are these
Lordship-
matters for?
Lordship, here the petitioner they have been out of service.
Huh?
Out of service.
Out of service.
Lordship, they're challenging the
Yeah,
Selling the
the termination
termination order, Lordship.
upon demand as to why the inquiry report by memorandum dated demand and the impugn order, removal order should not be set aside in quash being shown and after being quash the impugn inquiry report. Yes. Why these matters are taken together?
Lordship, they're from the same department.
The same allegation.
Same,
Same allegation.
same inquiry report.
Same allegation.
One inquiry report. Where is it, inquiry report?
Should be kindly take,
Let us take this one only, the item number
114 of 2022.
251.
Lordship,
251.
114 is the leading case.
Okay, 114.
Lordship, the 114 actually is wrongly listed today because, Your Lordship, there is already an order passed in 114. By order. This particular matter should be listed after 3 weeks. And this has not been tagged with other writ petitions, Your Lordship.
Now, there is some judgment. Where? This is a judgment of what? Oh, this is another judgment. Huh? Yes, what is this? A Songla Pongar? This is a different one. Why this judgment has been placed?
112 was
Ausenla
already discussed.
Ogner versus State of Nagaland. Any relevance? No.
Yes, there is.
Why?
112 and 114 were filed together. They have
Oh, 112.
similar issue. So,
112, what the court held? The inquiry report dated demand against the president and the demand hereby set aside and quash and the judge petition is allowed. I will make clear that the respondent are not precluded from conducting a fresh inquiry. Now, here it's a different inquiry or same inquiry?
Same inquiry, Lordship.
Huh?
Same inquiry.
Same.
Yes, Lordship.
You are challenging which inquiry?
The removal order was passed on the same day.
By 7/4/2022. This is 8/6. Oh, 7/4. In all the cases, 7/4 is the inquiry report. Huh?
No, Your Lordship, not in all cases. Dates are a little different, Your Lordship. However, the board is same. Inquiry board is same.
Now, what is the allegation is same?
Allegation also is same, Your Lordship. Allegation is a submission of fake document, Your Lordship.
On
all of them, but from different universities.
Maybe, but the submission of fake document.
Yes. So allegation is same.
Now, what has happened against this judgment in Asongla? Have you filed an appeal?
No, Your Lordship, because the state government has committed one error, Your Lordship. In the inquiry report, instead of the petitioner's name, the name of the petitioner in 114 is mentioned in one of the inquiry report.
Then
The-
that is
yeah.
that the reason why?
Yes, that is the ground taken by this honorable court in its order, Your Lordship. And that mistake, of course, we also have.
For others, there is no other problem.
No, others no, Your Lordship.
These are all fake certificates.
Lordship.
So, what was the post for? You were in
Private
some
teacher.
post.
Private teacher.
Private teacher.
Semi-graduate teacher.
Huh?
GT and PT, yes, graduate teacher.
Private teacher?
No, primary teachers and
teacher
graduate teachers.
and graduate teachers.
Okay. And they did not have the qualification.
Of not the university qualification, but the BA, that is the Bachelor of Education. That particular certificate which they have submitted to the department is found to be fact, which has been submitted by the university from where they have procured the BA certificate. So that was the reason why they were removed.
So in all other cases, that problem is not there.
No. The problem is not there.
We admit these petitions
Lordship.
and fix it for hearing.
Lordship.
Let them also have some solace. that the matter is pending on the bench. Taking into account that in the instant batch of writ petitions, the pleadings are complete.
Yes.
This court admits all the writ petitions and issues rule. First, the respondents are duly admitted, having already received copies of the writ petition and have also filed their replies. There is no necessity for further issuance of further service of extra copies of the writ petition, further service of extra copies of the writ petition. First, list these matters for hearing when?
2 weeks also. After 2 weeks.
So only?
Lordship, yes. However, Lordship, as I was making a mention, this item 114, if there is only an order pass, Your Lordship. So if
What order pass?
it was supposed to be listed by 12/2/24.
For what?
These matters, this particular matter, only this matter was supposed to be listed after 3 weeks for admission hearing.
No, I'm admitting everything.
Lordship, yes.
So we'll fix it on for 11th of March. Hearing on 11th of March.
If it can be on 12th, Lordship.
Very well. 12, I'm not there.
I am deeply obliged.
For admission, item number 21.
Yes, my lord. Lordship, I have filed affidavit in reply to the affidavit in opposition this morning. So that the matter come up for admission hearing, Lordship. Next week, oh, my lord.
Seniority.
Yes, Lordship.
No stay. Stay.
No, Lordship.
No stay.
No, Lordship. This place the outcome of the writ petition.
Said Zimomi, the learned counsel appearing on behalf of the petitioner, submits the affidavit in reply has been filed on behalf of the petitioner. The registry shall bring on record the said affidavit in petition. Affidavit in reply. List the matter on 4th of March.
4th of March, Lordship, I have
5th.
I have to appear before the principal bench.
7th.
7th, I have another. Anyway, Lordship.
7th. 7th of March.
For admission,
Obliged, Lordship.
item number 22.
Yes.
That is about it. On the last occasion, this honorable, my lord has passed an order in 12/2023, directing the Deputy Commissioner Kohima to file an affidavit.
Yes, what steps have you taken pursuant to the representation? Maybe. Yes. 8, 17.
11.
11, yes.
Public notice was issued.
Yes, then
Public notice was issued. Thereafter, lordship may kindly come to page
8,
12.
12,
The
yes.
next. The petition before in respect of previous stated notice. This was forwarded.
Okay, then.
So now the, far as the
So these
commissioner is concerned,
these petitioners fall within the bracket of these 18.
My
Does
lord.
the petitioners fall within the bracket of these 18? Now, you see, in pursuance to the notice which was issued, only 48 persons came for verification,
Lordship.
of which 30 have been recommended, 18 are not. And of these 18, you have not done on the ground that 6 are allotee tenant who have expired. Then that 10 are government servants and 2 are from the same family.
Lordship.
Then
And that was forwarded to the deputy commissioner. Deputy commissioner forwarded the matter to the principal secretary. However, after that, lordship, what happened was the petitioner, they filed one writ petition, which was numbered as 169 under the local represented by the president of the state union. That also was withdrawn. So in the present writ petition also, it was filed by the individual.
so there are now 2 writ petitions.
Earlier, what happened was after we file an affidavit non-petition.
This one?
No, earlier writ petition,
Ah.
which was numbered as 169 of 2. The petitioner
Withdrew.
lordship. And this is the subsequent writ petition filed by the.
And did they withdraw with the liberty?
Lordship, with the liberty to file a fresh one.
So this is one.
This is one.
Then
So, lordship,
now what has happened when it went to the principal secretary?
lordship, before the deputy commissioner forwarded the matter to the principal secretary, they have filed the previous writ petition.
Then that but that writ petition has been withdrawn.
Lordship. Again, in the meantime, again, they have filed the subsequent.
So therefore, I have asked you to tell me what action have you taken to their representation?
Lordship, in fact, the deputy commissioner's jurisdiction is very confined only to the verification. So verification has sent it to the.
No, but have you considered their representation or not? Because the representation was given to the deputy commissioner, isn't it?
Lordship, and they allow, lordship, and they allow some time to file a comprehensive affidavit on behalf of all the respondents. Since on the last occasion, it's on this order.
Because I have asked you a simple thing
Yes.
on the last occasion,
No.
that so and so appearing on behalf of the respondent directed to ensure that deputy commissioner files an affidavit in a matter on its merits,
No.
as well as also state as to what steps have been taken pursuant to the representation filed by the petitioners. What steps have you taken?
As far as
You must have stated in your affidavit, let us see.
lordship in the affidavit, we have comments.
Pursuant to the representation submitted by the petitioner, the answering acknowledging and thereafter verification of so you have mentioned it at paragraph number 2, 3. You have duly considered the representation. So So their basic case is here is that they should be granted allotment.
Lordship, in fact,
How many petitioners are here
Your Lordship, 46 petitioners, Your Lordship.
out of 48? Why didn't you participate, or have all of you participated in the pursuant to the notice?
Lordship, regarding this public notice, the latest public notice is this one that is issued on 24th March 2022. Your Lordship,
This is,
as per-
no, you submitted your representation on when? 2/4/2022.
Yes, Your Lordship. Yes, Your
And
Lordship.
then public notice was 24/3.
24th March 2022, Your Lordship. And as per the public notice, Your Lordship, we have received this public notice only on 31st March. And we have learned that 3 days has been given to us. And well, the direction of the public notice is that the aforementioned document in original should be produced. Whereas, Your Lordship, our difficulties is that, Your Lordship, many of the 46 petitioners, many of them, they did not have the original allotment order also. Your Lordship, and since because of all these difficulties, and in the allotment order, their names in the allotment order and their names in the Aadhaar card, it's many of them, I'll say, Your Lordship, their names are totally different. So in respect of that, they need time to bring correct declaration in affidavit also before the verification committee. And their names in the PAN card also and allotment order, it's totally different. Although the same person, so they are in need of sufficient time to clarify all this and bring this before the verification committee. And in respect of that, Your Lordship, representation letter has been given to the competent authorities seeking time. And some of them, Your Lordship, in the representation letter, some of them, they are difficult to appear before the verification committee because of old age and infirm. Some of them are sick. And
So
around
if
6
you
to
are
7,
sick, old age, why do you need the allotment?
Your Lordship, they have their special prayer that in respect of those persons, one of their next scheme may be given. And since it's a matter of 19 years, Your Lordship, they have waited for 19 years and still they have a dream that allotment will be given to them, Your Lordship. They have signed the MOU.
But those persons who are government servants, they are not entitled.
That was in respect of the latest
In the family,
verification
if there
committee,
is a government servant, they are not entitled to.
Your Lordship,
If there are persons who comes within the ambit of, you do one thing, those people who are government servant, let them relinquish their government servant, government job. He will be happy. There are a lot of other people who want the government jobs. So let them, it's on, because of the state of Nagaland is not in a position to have government jobs on account of fund constraint. So those 6 people, let them relinquish those jobs and then you will consider their allotment. What do you say?
Your Lordship, I may be allowed to give a submission, Your Lordship, during the signing of the MOU. After the completion of the supermarket building, it was given in the terms and condition that a committee will be set up. So, but after the reconstruction of the building has been completed, one of the grievance of the petitioner is that the constitution of the committee, they are not aware of the constitution of the committee also. And even, and if at
What
all,
are they going to do with the constitution? Do they have a say out there? Then look here, we want A, not B. Then, but the question is, were you in a position to submit your papers or not?
yes, Your Lordship.
You were.
Yes, Your Lordship. On 2 occasions, we have submitted the documents. Your Lordship, the competent authority has asked us to submit the documents. To submit the documents
So
in the
you
year
have submitted?
2020. Yes.
You have submitted documents?
Yes, and then in the year 2020, we have submitted all our documents, but for about 1 year, they did not take any step. In the
So
year
they will have the
2020.
records
Yes,
if you
Your
have
Lordship.
submitted?
Yes, Your Lordship.
So you will also have records?
Yes, Your Lordship. It's
Then-
in the petition.
Then
Your Lordship.
why are you saying that you don't have records? if you have submitted all the documents.
Lordship, Lordship, we have given a photocopy of all the, they have the photocopy. They do not have the original one, many of them, but they do have the Xerox copy. Some of them, they have given their no objection. And some of them, they have annexed their rental bill, even electricity bill, in order to prove that they are also at the previous tenants of the, and all of them have their room allotment numbers also, Your Lordship.
Now, tell me, are you, all the petitioners, 46 petitioners, did they participate pursuant to the public notice? No. Because as per the report, only 130 out of 136,
Yes, sir.
only 48 has come for verification.
Lordship, our
And
difficulties
of these 48, 30 have been recommended, meaning thereby 18 have not. Now, if there are 46 petitioners, obviously it is more than 18. So they may not have submitted their documents.
Lordship, we have our difficulties also, Your Lordship. We are willing to comply with the verification committee. However, if they are asking for the original, and if at all
But the
we have
thing is like
produced-
this, they will obviously ask for some document to show that yes, because tomorrow somebody else, another person will come in and say that look here, what to do? I'm actually the owner, he has manipulated the photography. That is the worry they have. How do you take care of that?
Lordship, they are of the view that if they just go blindly like this, they might have been rejected also.
Huh?
Lordship, so.
What rejected?
Without the original documents, many of them, Lordship. So they have
No,
given
no,
the
tell me,
presentation
how
letter.
can this court issue a writ asking them to look into the photography? Tell me.
Lordship, now the prayer of the 46 petitioners is that they are genuine previous tenants.
So
They are
of
willing
these
to-
46, many have not participated. That is what I'm saying all along. You see, therefore I'm saying out of the public notice, 136 persons were there, of which only 48 came up for verification. And if 48 came, 30 was given. 18 were rejected. Of these 18, but we have 46 petitioners. How is it possible? That means some of the petitioners, not saying about the 18, the remaining 28 petitioners have not participated in the verification process.
Yes.
Then
The letter that was signed 2003, that we have hearing and the petitioner.
what can be done?
Discuss.
Only thing, madam, I can do to help you is direct the deputy commissioner to give you another chance for submitting documents. Thereupon, the deputy commissioner will take a call on the response. That is the only thing I can give you. And on a particular date, giving you 15 days time for submission of all your documents, thereupon the deputy commissioner. That is the only thing. What do you say? That is the only thing. I can't do anything for it. I can't allow them to look into photocopies because there will some other people who will say that. If you want this 15 days or 30 days, I'm coming in 5 minutes, you let me know.
Your Lordship, by virtue of the MOU being signed, Your Lordship.
Understood,
Your
but
Lordship, if-
whatever
if
may
that's-
MOU,
That's not happening.
I can't help you
Lordship.
more than that. You want 15 days or 30 days, I'm coming at 11:45, you let me know. Coming. Yes, ma'am. The only help I can do to you is that, giving you another opportunity, that's all.
Sufficient time will be given. We will be-
Sufficient?
We will.
How
We
much?
are willing to comply with.
How much? 30 days?
Your lordship, 3 months time will be
No.
given.
There cannot be a delay. Then you deposit the rent for 3 months. You will be there losing or irrespective of any right accrued to you. I'll give you 6 months. Give 6 months of rent, isn't it? They can't lose. Because of this pendency of the instant writ petition, they are losing. Pay the rent. What do you say?
Case 60 days.
This matter has been
They will
pending since
produce
long.
the evidence, yes, sir.
So under such circumstances, the 30 days is the time. 30 days, reasonable. You submit. Okay. 46 writ petitioners have joined together to file the instant writ petition, challenging the actions of the respondent authorities in not granting the petition, say petitioners allotment in terms with the memorandum of understanding dated 1/8/2003. From materials on record, it reveals that the petitioners herein claimed that they were the previous tenants of a supermarket established by the Kohima Municipal Council, Kohima. In the year 2003 or 6, when did this allotment happen? I mean, you were out
2003, Your lordship.
in the year on 1/8/2003. A memorandum of understanding was executed between the Deputy Commissioner and the local traders union supermarket in presence of witnesses on various conditions, incorporating various terms and conditions. This memorandum of understanding was entered into in view of the decision of the respondents to demolish the existing structure and construct a new building. The said building was completed. The proposed building was completed after 19 years. And thereupon, the respondent authorities took steps for granting allotment. It is the case of the petitioners that the said steps taken by the respondent authorities in finalizing the allotments was without taking into account the memorandum of understanding entered into on 1/8/2003. It is the further case of the petitioners that all the petitioners did not have the time and opportunity, were not provided reasonable opportunity for placing their documents by the Deputy Commissioner Kohima, and resultantly their cases were not considered, which ought to have been considered in terms of the MOU dated 1/8/2003. Being agreed, a writ petition was filed by the local traders union supermarket, a union of the earlier allottees of the Kohima or of the building in Kochi. However, which was registered and numbered as WPC number 169/2022. However, the said writ petition was withdrawn with liberty, and thereupon the present writ petition has been filed by the petitioners. The record reveals that this court, by an order dated 15/12/2023, had issued notice making it returnable on 12/2/2024. On the same date, the Deputy Commissioner Kohima was directed to file an affidavit on merits, as well as also state as to what steps have been taken pursuant to the representation filed by the petitioners. The record reveals that the Deputy Commissioner had filed an affidavit stating inter alia that in pursuant to the representation dated 2/4/2022 submitted by the President of the Local Traders Union Supermarket, a public notice was issued on 24/3/2022, and thereafter verification of previous tenants of supermarket complex Kohima was held on 4/4/2022 to 6/4/2022. It was specifically mentioned that out of 136 applications received by the Kohima Municipal Corporation, a total of 48 persons came for verification, out of which 30 persons were recommended for allotment of the room at the new supermarket complex, and the remaining 18 persons were not recommended for various reasons. The said verification thereafter was forwarded to the Principal Secretary, Department of Urban Development and Municipal Affairs by the communication dated 24/2022 for necessary action. To the said affidavit, various enclosures have been enclosed, including the reports submitted to the Principal Secretary, Department of Urban Development and Municipal Affairs. From the said communication dated 24/2022, which was sent to the Principal Secretary, it is seen that out of the 136 applicants, 48 persons have appeared for verification, whereas out of the 48 persons, 30 persons were recommended for allotment, whereas 18 persons were not recommended for the following reasons. Number one, 6 persons, in the case of 6 persons, the allottee/tenant had expired. Number two, 10 of such applications were of government servants. Number 3, 2 of such applications pertain to allotment made two of such applications were in relation to the second allotment of the same family. This court have also taken note of Annexure 3, taken note of the list of allottees who were recommended, as could be seen from a perusal of the have taken note of the list of previous tenants of the allottees who were recommended for allotment of the room at the new supermarket complex. From the materials on record, it, however, does not transpire as to whether the petitioners herein are amongst the 18 persons who have been rejected, whose applications have been rejected. Be that as it may, this court have duly taken consideration of the submissions made by the learned counsel for the petitioner, and is of the opinion that as there was a memorandum of understanding dated 1/8/2003, and the petitioners claim that they have not been granted a reasonable opportunity of placing the documents, it is the opinion of this court that the petitioners should be given an additional opportunity. Taking into account the above, this court therefore disposes of the instant petition, thereby directing the respondent authorities, more particularly the Deputy Commissioner Kohima, to reconsider disposes of the instant petition by giving liberty to the petitioners to submit their applications, to submit their necessary documents before the Deputy Commissioner Kohima on or before what 20 on or before 2024. And if the petitioners duly submit such documents, the Deputy Commissioner, within the period so stipulated, the Deputy Commissioner Kohima shall consider the same, and as per the extant laws, extant laws, and the permissive and the prescriptions extant laws, consider the case of such petitioners and submit the report before the Principal Secretary accordingly. The said exercise be completed within a period of 3 months. That is what I'm saying. I'm only giving them the liberty to submit within 23. Yes. And that is what I'm saying. I'm only giving the liberty to the petitioners to submit by 2023, and thereupon within 3 months thereafter, they can do the needful with the above the petition stands.
For hearing item numbers 23 to 25.
Yeah, please, Lord, with your lordship, my lord. Well, only 2 weeks time. Because I sought some clarification in the affidavit in reply filed by the petitioner. Petitioner affidavit.
You want some clarification?
Yes, I have sought, but I'm yet to receive the instruction.
Yes.
as the present case is concerned.
You are the accountant general.
Yes.
I told them you were the accountant general. Yesterday there was a matter. So they say that there is no
Lordship,
standing counsel.
There are two of us.
Yes.
Mr. Joshua and myself, yes.
No, I told them there is one. They said that no, there was one matter yesterday. So I had to issue notice to the accountant general.
In fact, Lordship, at time of filing, we have even informed the registry that any cases where AG is a party, the notice should be served to us.
Yes.
But most of the time, without giving us copy.
Yesterday there was one motion, item number 1. Mr. Yes.
Apparently, they have not given notice to us.
Ah.
Because yesterday I was there in the court. I was in court number 2.
I asked them to find out who is it. They said no. I found out.
There are two of us, Mr. Joshua and myself.
I could enforce against them, against the Gauhati High Court Council was there, so there was no problem. I could say that the A. Zimomi is there. But for you, I knew it that you were the standing counsel because I was taking up in the division bench. I found out that you were taking up.
Yes, I
matters
am.
on these. But here the other lawyers did not know it. Okay, Mr. So and so appearing on behalf of. Oh, what are these matters? Why is this Atsumi's judgment here? This Justice MR's judgment. What is the matter, Mr. Hmm.
One is the son to be. He died while working in the electric post.
You wanted regularization.
One.
No. Did your person, was your person at that point of time eligible to be regularized at the time of death?
We are saying that we were not eligible.
Then when did you
Then
die?
we brought out the documents. Now they are saying that we have to seek clarification. Because all
No, you were appointed
all
when?
juniors, we were regularized.
85.
Additional affidavit in reply. The person who were much more.
You died when? Until he died in 2010.
Yes.
You were not you were a work charge.
No.
When were you promoted as a work charge?
First appointment was on 29/11/85.
Then
promoted
Hmm.
on 27/9/2000. Right on 16/23.
Umademi would not come in.
Regularized without going into the other matter.
How will Umademi come into the picture? How can this court direct regularization? Unless the policy says so. This court can very well say, yes, this is the policy concern, and you ought to look into these policies, and if not doing it, you will violate Article 14. That's all. So on the basis of the policy standing then, you are to therefore show that you were entitled to regularization, not on the basis of what happened later on. How can this court direct regularization? Uma Devi say that don't disturb those persons who have been regularized, who have been working out there for the last 10 years. Let us see that judgment. You see, have you looked into the judgment of the District Bar Association, Bandipora? We'll look into this judgment. Mr. Lamsar, we'll do one thing. We will take up this matter again. We'll go through the judgment of 2017 3 SCC 410. In the meantime, you get your instructions. Because there, Uma Devi has been explained by 3 judges. So, when a Supreme Court explains it, and there have been no, thereafter nothing has happened to that, because here all the other judgments have been taken, Renew and all, and said that the Renew and all, there is some, that Tiwari judgment, the Supreme Court said that this, the Tiwari judgment, they have digressed from what Uma Devi wanted to say. So, you have a look at the judgment, we'll take it up next week. Friday? Next week, Friday. No. Next week, Friday, I'll be leaving early. Thursday? Thursday? Mr. So-and-so appearing on behalf of the respondent seeks for an accommodation so that he can obtain instruction in respect to the additional affidavit in reply filed by the petition. This is the matter again on 29th of February 2020. You go through this judgment, then we'll.
For hearing, item number 26.
Yes.
Please, Your Lordship.
Yes.
Oh. Lordship.
Let it come up. I'll dismiss this petition.
Lordship. Oblige, Lordship.
This petition has to be dismissed. In my hands, it will get dismissed. Only thing which I wanted to give you, let it be, let these people decide that is a different thing, but this court otherwise is not.
In fact, after the
I'm against
yes.
you in this matter.
In fact, after the direction of the Dissolved Court, I applied to the office of the Commissioner Nagaland, the Home Commissioner Lordship, and the Commissioner Nagaland to a request to furnish the documents with regard to the mode of appointment, including rules or guidelines regulating the appointment or promotion of the petitioners, that is the village guards, junior commission officers. Lordship, we received the reply, but the draft service rules is of 2014 and they were all appointed prior to that, Lordship. They have
But
been in
how can
service
you
prior to
equate
that.
them with this? Very difficult.
So, Lordship, as far as the duties, the nature of the duties they are performing, all this, Lord, they cannot be said to be inferior to Nagaland Police, Lordship. And by the declaration of the ROP rules of 1993 itself, it was declared that they are of corresponding service, which the state later on began to misinterpret, and that's the reason why they have approached this Dissolved Court.
There, so Appointment is different. How are the village guards appointed?
So initially they are appointed, they are appointed on the basis of being an honorary service. And some of them have been promoted from the honorary service, that is still the rank of Sergeant Havildar. And till the rank of Havildar, they are not state employees. Once they get promoted from Havildar to Jamadar, then they become state employees, Lord. So Jamadar, Subidar Major, and Assistant Commandant.
So how do you equate them with this police? The recruitment is completely.
By the nature of duty they perform, Lordship. In fact,
And nature of duty recruitment is also a major thing in view of the second judgment after Jagjeet Singh, which I give it to you.
Lordship, the 2019 judgment. Okay, Lordship, we'll try another.
Another
bench.
bench will be better.
Oblige you, Lordship.
And but next time, so I'm telling you one thing. Next time, if the matter comes, then it is something like this, that the matter has to be disposed of by this court. I have given you opportunity in this matter since February 2022. We are in February.
To refer the matter before the
2 years you
commission.
have not been able to get it disposed to some other court.
If by default, Lordship, if by default the matter gets listed before your Lordship again, then I will take the first suggestion given by your Lordship.
Then in that case, next time it comes, next time whenever I come, if this matter comes up, then you know the fate.
So pay a nominally commission, Lordship. Oblige you, Lordship.
This is the matter after 2 weeks.
Lordship.
For admission, item number, for hearing, item number 28.
What is this matter about?
Lordship, it's on compassionate ground appointment.
What?
Compassionate ground appointment.
Compassionate appointment?
Yes.
Yes. Railways?
Railways.
Then?
Your Lordship, my wife expired on 23/5/2004. And
Your wife?
yes.
Yes.
And she was a regular employee of railway. And since after
2004.
2004.
And what do you do?
Thereafter, we have communicated through our applications and representations to the railway. But
So what do you do?
I am a fourth grade employee.
Then?
My wife, in fact.
No, what you do?
As of now, I am unemployed.
You in 2004, your
My
wife died.
Wife expired.
And till now, how are you surviving?
Daily library, Your Lordship.
From then?
From then.
And when did you apply?
Apply to the railways in the year 2006, actually.
Then what happened?
Then they have denied. First, they haven't admitted my position as an husband. Number one. Thereafter, they told me to bring succession certificate. I approached concerned additional deputy commissioner of Dimapur. I got the succession certificate. Now, thereafter, I'm a layman of her past class 8, Your Lordship, and thereafter they told me to bring the proceedings of that succession certificate from the court below, and that was not allowed by the concerned ADC. Thereafter, I approached to the railways again, that railway through their application can ask clarification as to whether that succession certificate was genuine or not. But here, may I take Your Lordship to this?
No, show me. They have a scheme. Railways have a scheme for
Yes,
compassion. Where is
yes,
it?
yes.
Page 40.
Yeah. page 40, the relevant page. Appointment on compassionate ground.
You don't have sons and daughters?
One daughter, one daughter.
Then
And I'm taking care of her.
why is she not applying?
Uh,
And how are you taking care of her?
She was a minor then actually when I applied in 2006 when I applied. She was 8 years then.
So now she has already become major.
Yes.
2006, 2006, she was 8 years.
Yes.
And now we have already 18 years. She will be 26.
Yes.
And you are 47?
My age. Nine.
49. As of now.
49 now.
Then this is a good D post.
D post.
Is it a right? Compassionate appointment is a right?
Yes, so far the railways establishment rules says.
What does it say?
Lordship may take to page 42. Page 42 of that. And the last para. Normally the appointment on compassionate grounds should be made within 1 month for item 1. That is, item 1 is that who expires in duty. And within 3 months for others, but all out efforts should be made to offer appointment as early as possible. A period of 5 years from the date of occurrence of event is prescribed as period of eligibility of entitlement of appointment on compassionate ground, which may be relaxed up to 20 years with the approval of general manager.
In all cases of death of an employee while in service with a widow cannot take up employment, so that case may be kept pending in the first. But where is it given that the husband will get it?
Lordships, so far page 40 goes, it's the dependents of the employee who die or permanently crippled in the course of duty.
How are you dependent? You dependent, but here you don't find anything. Duty for equipment to the women are exclusively reserved for widows, and with respect to those post minimum qualifications are now prescribed, and now prescribed will not be. So this is only, you are asking for group D, which is only for widows. How do you get it? Like for group C, it is widower. And recently the Supreme Court came up with a judgment that a person who, whatever post he was holding, the compassionate appointment cannot be higher than that. You are holding good D, then how do you bring the widower? We use another ER out there. Therefore, if you see that normally the portion you have ready,
Yes,
it says about the widow. And thereupon, if the widow does not have the qualification of cannot, then the daughter can die. That is why I asked you why
Yeah.
the daughter is not there.
that relevant portion, Lordship, may I take your Lordship to just that affidavit in opposition filed by the respondents.
Why?
They have, they represented the respondents railways, they have said that I had that right, but I haven't approached in time.
No,
That-
time and no time, that is different.
Yes.
First of all, it can be relaxed in the case of the woman. Why? But in your case, how you are entitled to good deed? Forget about what they say in the affidavit. As of now, if we apply the compassionate appointment rules, provisions,
Yes.
or the law as laid out by the Supreme Court, in more particularly the recent judgment of Justice Nagaratna,
Yes.
there obviously you are not at all entitled. But the railways have a different, railways, CRPF, all the central government have a particular different thing where they allow, just for example, 5 years, 10 years, they are allowing.
Yes.
You see this. But how will you get it? A good deal. Like for group C, if you see, widower is given. See, son, daughter, widow, or they are eligible for appointment of a. In the case of candidates having minimum qualification of a group C, so and so, yes, this is this. But here it is, and you see, for recruitment in group D, the following posts for appointment on compassionate are exclusively reserved for widows. And how are you surviving all these years, 2004 onwards?
Daily wage laborer, Lordship.
So,
yes.
So you are surviving for last 20 years. What is the basis for appointment on compassionate grounds? Don't have a right. Here also it says cases should not be more than 15 years from the date. Because the basic idea of compassionate appointment that the person concerned, he loses the entire, the bread earner having left out there, nothing remains, for which there is a requirement to be urgently taken care of so that they are retrieved from agony and all. And that is why it says that within 1 month it should be done, or 3 months. That's all. And if a person concerned is a minor out there and the widow cannot do so, then 5 years or 10 years can be relaxed out. But if you are the husband, why do you know? What right do you have?
Yeah, at that time, actually, Lordship, my daughter was, when she died, she was 6 years old only.
So obviously for
Yes.
her it could have been wait. That is why I put that question to you.
Yes.
About the husband, why? She should have applied for that. You could have very well said that, look here, okay, now once she has become 18 or 19 or 20, you should have. So you waited around very well without any problem for 20 years. Today, you are surviving. Your lawyer out here in Gauhati, Kohima.
No, here in Dimapur.
Okay. So he has the money to bring a lawyer from Dimapur also. Then, and this is a case of compassionate appointment.
Maybe given a little time, your lordship, in the meantime, if I can explain that part.
You see, the basic idea we have in the you have seen the judgment on this, no? Where is the judgment which
Or if your lordship can issue a direction, at least the daughter, so that the daughter can apply. Because your lordship, in that affidavit in opposition,
that they are saying want to be delayed.
yeah, they are saying that I was sleeping with my rights and all. They in one such para, they have said that they have no such records that I have applied for compassionate appointment. But one such document clearly proves that they have received.
So these are there, but then also help it on the case. The judge. State of West Bengal versus Debabrata Tiwari. Judgment the Supreme Court has come down very heavily on this compassionate appointment. The extent of saying this and I've dealt with all the judgments. On consideration of the above provision, decisions of this court, the following principles emerge. That a provision for compassionate appointment makes a departure from the general provision providing for appointment to a post by following a particular procedure of recruitment. Since a provision enables appointment being made without following the same process, it is in the nature of an exception to the general provision and must be resorted to only in order to achieve the stated objective, that is to enable the family of the deceased to get over the sudden financial crisis. Appointment on compassionate grounds is not a source of recruitment. The reason for making such a benevolent scheme by the state or the public sector undertaking is to see that the dependent of the deceased are not deprived of the means of livelihood. It is only enables the family of the deceased to get over the sudden financial crisis. Compassionate appointment is not a vested right which can be exercised at any time in future. Compassionate employment cannot be claimed or offered after a lapse of time and after the crisis is over. That compassionate appointment should be provided immediately to redeem the family in distress. And here further the Supreme Court says The object underlying a provision for grant of compassionate appointment is to enable the family of the deceased to tide over the sudden crisis due to the death of the breadwinner, which has left the family in a penury and without any means of livelihood. Out of pure humanitarian consideration and having regard to the fact that unless sometime some source of livelihood is provided, the family would not be in a position to make both ends meet. A provision is made for giving gainful employment to one of the dependents of the deceased who may be eligible for such employment. Having regard to such an object, it will be of no avail to grant compassionate appointment to the deceased, dependents of the deceased after the crisis which arose on account. Thus, there is also a compelling need to act with a sense of immediacy in matters. Then the Supreme Court goes on to further say that if an application is pending for a long time, then also you should not grant it. Secondly, considering the second question referred to is the first we said regarding whether an application for compassionate appointment to be considered after a delay of several years. We are of the view that in a case where for reasons of prolonged delay, either on the part of the applicant in claiming compassionate or the authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves most probably by availing gainful employment for another. Granting compassionate appointment in such a case, as noted by this court in Hakim Singh, would amount to treating a claim for compassionate appointment as though it was a matter of inheritance. Which is your case? You got that job from your wife. Notice the fit case for dismissal. Very interesting.
May we allow a little time, your worship, so that I can, so that as regards to that great CF, that I have understood what your lordship has just directed.
Oh, here, somebody gave this judgment also here. I was looking up, trying to find out. This judgment is also here in the correct. Then you gave it.
Yes. Yes.
You see, Malayananda Sethi is a different thing. Malayananda Sethi judgment of Justice Amasa is on a different line. He says that the entire mistake was committed by him and therefore has directed for reconsideration. What?
Short time area allowed to me.
Tomorrow?
So I can come more clear before your lordship next week if possible.
Monday. The request of the Level Council for the petition matter be listed again on Monday.
For hearing item numbers 29 to 33.
Yes, what are these? Land compensation.
By an order dated 15 of 11, 2023, Lord. I was directed to file an affidavit.
20?
11, 2023.
1311.
1311.
You are appearing for whom?
I'm for respondent number 6, Lord, NHIDCL.
Then why haven't you filed?
As per the direction of this honorable court, Lordship, the query was advanced to the NHIDCL, Lordship, pertaining to a decision of the authorities whether a stretch of road under Bond Town, Lordship, whether that stretch of road is for widening or to strengthen, Lordship. So I've prepared my affidavit, Lordship. I'm enclosing the copy of the contract agreement, Lordship, and also the DPR, Lordship, which says that there's no provision for widening, Lordship. It is only for strengthening, Lordship. And that is also one of the prayers in the petition. If I may be allowed a week's time to file the affidavit, Lordship. I've already prepared, I've forwarded it for approval, Lordship, to the headquarters of Delhi, Lordship. If I may be given a week's time.
The legal counsel is appearing on behalf of who?
Respondent number 6, Lordship.
Respondent number 6 submits that this court by an order dated 13/11/2023 had directed the NHIDCL to file an affidavit. However, the said affidavit has not yet been filed. The record reveals that on 5/2/2024 also, time was sought for filing the affidavit. This court grants an final chance, final opportunity to the NH respondent number 6 to file the affidavit without fail. This is the matter again on 11th of March. In the meantime, the affidavit will be filed by 4th March.
Much less.
For hearing, item numbers 34 to 42.
Yes, what is this? Minimum.
Your Lordship,
Granting higher pay scale, what is this?
Your Lordship, I need this matter after 2 weeks. Since
After?
my 2 weeks.
Why?
Since my seniors in
You
the.
don't want to do before this court? Huh? Oh, yes, yes. Morning you mentioned, no? The legal counsel, Ms. So-and-so submits that Mr. So-and-so is in bereavement. So taking into account the above, the matter stands adjourned to be listed. Matter stands adjourned to be listed again on 11th of March.
For hearing, item number 43.
Yes. Compassionate appointment.
Yes, Lordship.
Where? Direct the respondent to consider the petition as applicable for compassionate on the grounds of demand. Yes, what is the status of his? Once he files there, you have a particular, you put it in a particular serial number, na?
Yes, my lord.
What
My
is
lord,
this?
here the petitioner they have submitted the representation. However, our stand is in the office, we don't have the report. That is why we could not consider we could not consider his prayer.
Let us see his, what is the scheme you have? Where is the scheme? Yes, compassionate appointment may be made to the post falling under the combined direct recruitment C and D, the ceiling for compassionate appointment. Interest of persons appointed under which and be fixed with reference to that date of appointment and the interpolation with the direct report shall be made.
by the government of Nagaland.
Shall be strictly in the order of death and first preference shall be given against those who have died earlier and includes all others. So in view of 9/4/2019, he can today also submit
Yes,
if
my
you
lord.
don't have the records.
Yes, we don't have the report.
Then in that case, you are to take into account the date of death.
So my lord, my humble submission is for the justice of justice.
Let him
the
submit
petitioner submit the-
and it will be taken note of. What do you
Yes.
say?
Even otherwise,
Correction may be
for a
issued.
moment, Lordship, if you're watching the kindly, page 18, Lordship. This is the application of the petitioner, Lordship. And it shows that the application was received, Lordship.
So they say don't have the record.
Yes, Lordship.
So this is the date of
This can be
receipt,
considered, Lordship.
26/11/2012. It was
Yes.
duly received. And there was a number given, 1175.
Yes, Lordship. Yes.
So if we have given a number, is the number relevant with that particular point of time? I mean, so you maintain the serial number at that point of time?
Yes, the department must maintain this. So,
Anyways,
yes.
whenever they apply,
Yes.
now this is your addendum. Addendum says, compassionate appointment made to group C or D posts under this scheme shall be strictly in order of the date of death.
Yes.
And first preference shall always be given against those who have died earlier and who fulfills all other eligibility criteria. So under such circumstances, you can treat this application also, or he will submit a fresh representation also.
Let
No,
him submit
but
the fresh
whatever may be, it has to be taken in terms with the addendum.
Yes, my lord, yes. my lord.
We will record that you will,
Yes.
that you
So,
will
my
take
lord,
into account on the basis of this addendum.
Yes, that the concerned respondent will verify the case of the petitioner.
They will
If not
require, they will do
given,
it.
will consider-
Your basic thing is that his application is not there with
Yes,
you
sir.
in your records.
Yes, that is all.
Whereas he said that the application was duly received on 26/11/2022, 12.
Sure.
26/11/2012. Be that as it may, he can very well submit, and as per this 2019 addendum, it will be on the basis of date of death.
Yes.
So date of death will be taken into account.
Yes.
I think that is a fair thing. for
Yes.
both of you. The instant writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the responding authorities in not considering the application filed by the petitioner for compassionate appointment. The materials on the court show that the petitioner herein show that the father of the petitioner, one Kampo Konyak, since deceased, was temporarily appointed to the post of grade 3 EB under the establishment of the Deputy Commissioner, Mon Nagaland. Subsequently, after a period of 2 years on probation, the service of the petitioner's father was regularized by an order dated 26/6/1989 and was duly paid and was granted a pay scale. Unfortunately, the father of the petitioner expired on 19/2/2009. To that effect, the death certificate of the father of the petitioner, dated 31/3/2009, have been enclosed as Annexure C to the petition. Thereupon, the petitioner filed an application on 26/11/2012 for appointment on seeking appointment on compassionate basis. In terms of seeking appointment, as per the seeking appointment on compassionate basis, inasmuch as it is claimed by the petitioner that the petitioner was eligible. However, the said application was not taken into account and not considered by the respondent authorities for which the petitioner has approached this court by filing a writ petition. This court have heard the learned had filed the writ petition on 18/7/2022. The record reveals that the affidavit in opposition has been filed with respondent number 1, 2, and 3, wherein it has been mentioned that though the application which have been enclosed in Annex D to the writ petition bore the seal, received seal of the respondent's office, but there is no records available in the office in respect to the petitioner's application and further course of action taken. The said, from a perusal of the said affidavit, the only reason why the petitioners, it appears that the only reason for which the petitioner's application have not been considered is that the records of the petitioner's application is not available in the office. This court have also heard it is also apparent that the petitioner had filed an affidavit in reply stating inter alia that the petitioner's application was duly filed and was given a serial number bearing 1175. This court have duly heard the learned counsels appearing on behalf of the parties as well as also and have duly given its anxious consideration. The only reason why the petitioner's application has not been taken into consideration by the respondent authorities is on the ground that the petitioner's application is not available in the reports. On the other hand, from a perusal of the said application which has been enclosed as Annex D to the petition, it reveals that the same bears a seal of the department in question as well as also the serial number has been given as 1175. In paragraph number 5 of the affidavit in opposition, the respondents duly admit that the seal belongs to the respondent department. Be it as it may, this court have also taken note of the office memorandum dated 7/9/2015, as well as the addendum dated 9/4/2019. The addendum by the said addendum dated 9/4/2019, paragraph 11 was inserted to the office memorandum dated 7/9/2015, whereby it has been mandated that a compassionate appointment made to Group C and Group D posts under the scheme shall be strictly in order of the date of death, and first preference shall always be given against those who have died earlier and who fulfills all other eligibility criteria. Considering the above, this court is of the opinion that this court is of the opinion that if a liberty is given to the petitioner to submit a fresh application, the said application shall be considered in terms of paragraph 11, and a direction is given to the respondent authority to consider the said application in terms of para 11 of the office memorandum dated 17/9/2015. The same would meet the ends of justice. Considering the above, this court therefore disposes of the instant petition, thereby granting the liberty to the petitioner to file a fresh representation, along with thereby enclosing the application which was filed on a photocopy of the application, which was filed on 26/11/2012. And on the basis of, and upon such application being filed by the representation being filed by the petitioner, the respondent authorities shall duly consider the application of the petitioner in terms with the office memorandum dated 7/9/2015, and more particularly taking note of para 11, which was inserted by the addendum dated 9/4/2019 to the office memorandum dated 17/9/2015. With the above directions, the said access, with the above observations and directions, the petition stands disposed.
For hearing, item number 45.
Yes. What are you asking?
My colleagues has adjourned this matter this morning.
Oh, this has been mentioned. This has been mentioned by just Mr. Moore. On the ground that the matter is pending. Is this the one? Yes, I remember this. Now, some matter was mentioned in the morning. Which matter was that? Who was there in the morning? This is mentioned. 45 was mentioned. 44 was mentioned. 44 was mentioned, not 45. Yes, what is this?
Ownership, the petitioner is agreed. Number 7. Who is to know the petitioner? There are issues about first, how the indices only the same boss. The second point to be decided lordship is whether the recommendation of the TBC is uncommunicated AC is only top. Because the DBC considered the promotions based on uncommunicated ACRs of the petitioner.
Who has been promoted? Respond number 7. Who is appearing for 7? Yes, you. Two days, other two matters. After that. Yes, Mr. Counselor. Yeah, ma'am. Yes. Why?
Other matters are there. I have a receipt. What have letter?
Today?
Yes, yes, that's true.
See? I think before that it will, the matter will be taken up. Don't worry. I'll accommodate you. Don't worry. Yes. This matter. Invalid pension.
For hearing from the supplementary portions, item number 67.
May proceed, Lordship. Lordship, I would like to rely on the submission made yesterday. No further submission. But if your Lordship permits me to place two decisions. One is by dishonorable court and then other by Supreme Court.
Now, first of all, your invalid pension.
Yes.
I am in your favor, but
Lordship.
the only thing is it a case of invalid pension or disability pension?
Lordship, as per the approval made by the authority, it's an invalid pension. As per the approval made by the.
That is okay,
Yes.
but you see, how did this happen? See, there is a difference between an invalid pension and a disability pension.
Lordship.
A disability pension happens when the employer finds that this person is disabled and as such lets him go. And thereupon 49 cannot be applied. That law is set. But in the case of invalid pension, whether 49 will come into play or not.
Lordship, according to me, I was released from the service on invalid pension. And then as per the.
Now, did you ask for that? Because
Yes.
there is thing is like this. If you ask, it is invalid. If the employer asks you to leave, then it is feasible.
Lordship.
Yes, madam, your matter.
Lordship. See, on the facts and circumstances, no, that I was advised to take invalid pension, and then being a simple man, and then the
Let
honest
us
man.
see how it happened.
Lordship.
What have you stated in your petition? What were you working? What work were you doing?
Working as a constable, chief constable. Lordship. And then-
Constable?
Yes, and then I was appointed on regular basis. And then my statement start from paragraph 4. Lordship. How I was given the invalid pension.
Yes, what judgments you were submitting?
Lordship, there is one. Lordship, the relevant paragraph starts from paragraph 3. If I am to read, start from paragraph 3. Lordship. Mr. Rimogam, learned counsel for the petitioner submits that under the Central Civil Service Pension Rules 1972, in short, the pension rules 1972, more particularly Rule 34 provides that there is no prescription for length of service, and therefore the respondent cannot involve something which is not provided in pension rules 1972. The contention of the respondent that as the petitioner has not completed 10 years of service, and therefore he is not entitled to invalid pension, he is therefore not entitled to invalid. Therefore, a direction to be issued to respond to forthwith several invalid pension in favor of the petition. Then the counsel for the petitioner has also drawn the attention at this court in the case of the case for last decision of reported in 2014, 868, wherein in a sum civil matter, this court is observed that the extent in which of Rule 38 cannot be controlled by Rule 49(2) by words which are not there in the statement. 5. And this case may be then the following submits a credit of therefore, as the petitioner has not 10 years of qualifying years of service, in a position Mr. Prosecutor, standing counsel for the AG, Nathan submits that invalid pension is not based on the qualifying service, but depends on the medical certificate issued by the 8. This court is of the considered opinion that Rule 38 of the pension rules 1972 indicates that there is no prescription with regard to the length of service or that invalid pension shall be a considered point on completion of 10 years.
Who was the respondent before the Accountant General? Here we are having the Accountant General. It is a case where the Accountant General have duly accepted. This is the reason why the court had passed the order.
Lordship, here, my approval was given by the state responding member of this state responding. That is why on that agree, I'm going to this court. On the basis of the approval made by the state respondent, I'm agreed for non-consideration of that approval. That is why I'm approaching this.
What approval?
This for invalid pension.
You are given invalid pension. You are invalid.
Lordship.
You have gone invalid retirement.
After that, there is no more process. It stops there saying that I have not completed 10 years.
10 years. But here, the Accountant General gave a concession.
Lordship, though facts may be different, but the legal question.
It is on the basis of the concession the court has passed the order.
Lordship, and then what I'm trying to say is that invalid pension, in regard to the invalid pension, nowhere in that invalid pension it is mentioned about the end of years. That's what I want to emphasize on that. Lordship. And the second point, I would like to place one. Yesterday I have given in that 2008 SCC 648. I mean, it's a very brief judgment. I'd like to read one this 2008 SCC 648. Here on the legislation delay of approaching this multi 2008 SCC 648. It's a Union of India Matters versus Direction Civil. So, Lordship, here the vision remains almost same.
This is on delay.
So I just want
no, there's no problem with that. You are asking on the question of delay, limitation, recurring. So with delay, every day is a cause cause of action. Every month. Every month there will be a cause of action.
That is why Lordship yesterday there was on. So that's one of the business.
No, but tell me, this amendment of, you see, your basis is on this particular office memorandum. 2019.
And Lordship, see, Lordship, I like to highlight a little bit on this, Lordship. The 2015 office memorandum issued by the state respondent is in deviation of the CCS rule.
No, because 2000, this amendment, which is that have been amended, you see, the undersigned is directed to see that the rule 38 and 49 of the central pension rules have been amended by notification number dated demand copy enclosed. Where is the copy enclosed?
Lordship.
Where is the copy enclosed? Okay.
The whole, I'll paste the, Lordship, I made an apology that yesterday I think only the adopted page, but it is the whole contents of it. Because it has been in the language.
But with your two fingers being chopped out, how do you become personally totally incapacitated?
Lordship, see, as for the facts, that I was embarrassed and discouraged sometimes. Lordship.
Discouraged.
And then see, I was instructed to take an invalid petition.
You have taken it, but you have applied by yourself. And how do you see this amendment, this office memorandum will only be applicable in a case where after 2019 amendment, because there is an amendment in Rule 49.
Lordship, see, this CCS rule 1972 still exists and still exists.
No.
And then,
but this was amended. The thing was this notification is very relevant.
Lordship, that is why I'm saying that. Now I have not.
So this amendment will be prospectively. It can't be made retrospectively.
Lordship, but no.
So this makes it very clear that you have to have prior to 2019.
Lordship, that is why what I'm trying to say is that 2015, just for the sake of condition that I'm not in reached 10 years, the state respondent has deviated from the principal central service rules, because nowhere in the invalid pension it has been stated about 10 years, Lordship. That is what my condition, Lordship. So with all this, now I conclude my submission and then
the petitioner retired in 1994. And after a lapse of 30 years, we are going to this court. So it's a pretty long delay. He could not avail in the because of his short length of service. This amendment will come into force from the date of publication in the future. So the amendment
okay. The petitioner herein has approached this court seeking a direction upon the respondents consider the petitioner's invalid pension and any other service benefit and other consequential interest with effect from the date of administrative approval and release order of the petitioner's invalid pension without further delay. I've heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, and so-and-so appearing on behalf of the respondent. The facts involved in the instant case, as would appear from a perusal of the pleadings, is that the petitioner was initially appointed as recruit GD constable against an existing vacancy by an order dated 23/8/1983, issued by the commandant, 3rd Battalion, NAP, Tuansang, Nagaland. After the petitioner was appointed as a GB constable, the petitioner was attached to the then commandant, 3rd NAP Battalion, Tuansang, Nagaland, and was deputed to work under the then commandant's supervision to help and support in the domestic household works. Unfortunately, sometime in the year 1987, the petitioner while the petitioner's finger was chopped out at the time of cutting the firewood. It is claimed by the petitioner that the same happened during the course of performing his official duties. The record reveals that the petitioner thereupon applied for invalid pension, and on 28/3/1991, the commandant, 3rd NAP Battalion, Tuansang, had issued the approval and release order to the effect thereupon the petitioner approached the state respondents on various occasions for grant of his pension and other pensionary benefits on the basis of his release order as invalid pension, on the basis of his release order. Sometime in the year 1995, the petitioner was informed by the respondent authorities that on account of the petitioner not having 10 years of service, he would not be entitled to the invalid pension. Would not be entitled to any pension or pensionary benefits. Thereupon, the petitioner did not take any further steps, and sometime in the year 2021, and to be precise, on 29/4/2021, the petitioner submitted a representation requesting the state respondents to consider the petitioner's application for invalid pension and or other service benefits. However, the same not being granted, the petitioner has approached this court by filing the instant writ petition, seeking the reliefs as above stated. The record reveals that this court, by an order dated 6/8/2021, issued notice. The respondent numbers 1, 2, and 3 had filed an affidavit in opposition on 9/3/2022, stating inter alia that the petitioner was duly informed as far back as in the year 1991 itself that he would not be entitled to any pensionary benefits except the General Provident Fund, and in that regard, an amount of rupees 25,000 and 7,000 were duly paid to the petitioner. A perusal of the said affidavit in opposition clearly reveals that the reason why the petitioner have not been granted the benefit of any pension or pensionary benefit, have not been granted any pension or pensionary benefits, is that the petitioner did not have the length of service of 10 years. The record reveals that there's an additional affidavit in opposition filed by the respondent numbers 1, 2, and 3 pursuant to an order passed by this court on 1/5/2023, whereby an office memorandum dated 22/12/2015 was brought on record. This court had duly taken note of the said office memorandum, which specifically stipulates the date, office memorandum dated 22/12. This court had duly taken note of the office memorandum, which categorically states that for being entitled to an invalid pension under Rule 38, an employee has to have a qualifying service of less than, has to have a qualifying service of not less than 10 years. This court have duly heard the learned counsels appearing on behalf of the petitioner. In the backdrop of the above pleadings, this court have duly taken note of the submissions so made by the learned counsels appearing on behalf of the parties. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that on account of the petitioner being discouraged and sometimes teased, as he did not have teased, the petitioner was compelled to apply for the invalid pension. He further submitted that the petitioner applied for the invalid pension only for the reason, only on the basis of the assurance given by the then Director General of Police. No, who has given you the assurance? Huh? By the commandant of the 3rd NAP battalion, that the petitioner would be duly paid his pension and other service benefits. It is under such circumstances that the petitioner had submitted his papers and was granted a release order on 28/3/1991. He submitted further that though the petitioner did not agitate before this court, for almost 30 years, but not granting the pension and other service benefits is a continuing cause of action, and as such, it cannot be said that there has been any delay or laches. In that regard, the Learned Counsel drew the attention of this court to the judgment of the Supreme Court in the case of, where is that? Oh, you gave it to me. Case of Union of India and others versus Tarsem Singh, reported in 2008, 8 SSC 648. The Learned Counsel further submitted that in a similar circumstances, the coordinate bench of this court, in the case of Sriluti, Sriluti AO, versus the state of Nagaland and others, bracket, WPC number 228K/2014. In the judgment dated 14/5/2015, had granted the benefit of pension and service benefits and other service benefits, in spite of the petitioner therein not having the qualifying service of 10 years. The Learned Counsel further drew the attention of this court to the office memorandum dated 12/2/2019, whereby the Government of India, Ministry of Personnel, Public Grievances and Pensions, bracket, Department of Pension and Pensioners Welfare, bracket close, had categorically clarified that the period of 10 years of qualifying service is not required in the case of invalid pension. Anything else? On the other hand, Ms. So-and-so, the Learned Counsel appearing on behalf of the respondent, submitted that this circular, this office memorandum dated 12/2/2019 cannot be applied to the instant case, inasmuch as a perusal of the said office memorandum would categorically show that the said office memorandum had issued certain clarifications on the basis of the amendment made to Rule 38 and 49 by the notification bearing number 21/1/2016-PNPW bracket F dated 4/1/2019. Therefore, it is the submission of Learned Counsel for the respondent that the said office memorandum, having been based on the amendment made to the rules 38 and 49, with effect from 4/1/2019, the same cannot be applied to the instant case inasmuch as the petitioner had retired, had retired from service on 28/3/1991. The learned counsel for the petitioner respondent further submitted that the petitioner further submitted that this is not a case of a disability pension, but is a case of an invalid pension, whereby the petitioner himself had applied for being released from the service, and as such, the petitioner has to qualify in terms with Rule 49 as it existed then to be entitled to any pension or service benefits. The learned counsel for the respondent further submitted that the judgment in the case of Siluti Au cannot be made applicable to the present facts, taking into account that the said judgment was rendered in the facts of that case, and more particularly when the respondent number 4, that is the Accountant General Nagaland, had made certain concessions in the said affidavit in opposition filed therein. She therefore submitted that in the instant case, there is no such concessions so given. The learned counsel further submitted that in the instant case, the petitioner admittedly was informed in the year 1995 that he would not be granted any pension or service benefits, and for which the petitioner was paid an amount of rupees 25,000 as well as 7,000, which the petitioner duly accepted, and thereupon, almost after 30 years from the date on which the petitioner was released from service, the petitioner has approached this court. She therefore submitted that it is a pure and simple case of delay and laches for which the writ petition should be dismissed. Anything else, madam? This court have given an anxious consideration to the submissions so made by the learned counsels appearing on behalf of the parties. First, invalid pension under Rule 38 of the Central Civil Service pension close rules 1972 for short the rules of 1972, can be granted to a government servant when the government servant retires from service on account of any bodily or mental infirmity which has permanently incapacitated him from his service. Incapacitated him for his service. A government servant applying for such invalid pension is required to submit a medical certificate of incapacity issued by a medical board, comma, in case of gazetted and non-gazetted government servant, comma, who is getting a pay not exceeding a certain amount per mense, and in case of other employees, such certificate is to be issued by a civil servant or a district medical officer or medical officer of equivalent status. Rule 3, capital A bracket, of the rules of a further perusal of Rule 38 of the rules of 1972 also shows that the same rules will apply when a government servant seeks invalidation for any bodily or mental infirmity. Therefore, in a case of an invalid pension, it is the employee who seeks discharge, and this court at this stage also finds it relevant to take note of that Rule 3Q of the rules of 1972 defines qualifying service to mean service rendered while on duty or otherwise, which shall be taken into account for the purpose of pensions and gratuities if admissible under the rules of 1972. Rule 49 Rule 13 provides that the qualifying service by a government servant commences from the date from which he takes charge of the post to which he is first appointed, either substantively or in an officiating or temporary capacity. This rule nowhere provides that the qualifying service for getting pension is 10 years. On the contrary, there is a specific provision that if a government servant retires before completing qualifying service of 10 years, which is stipulated in Rule 49, that is because of his attaining the age of compulsory retirement, he would not get pension but would get the amount of service gratuity calculated at the rate of half month's emoluments for every completed 6 monthly period of qualifying service. Further to that, clause 2, bracket A of Rule 49 of the rules of 1972 specifically provides for grant of pension if a person government servant retires after completing, that is not. This court have also taken note of that by the notification dated 4/1/2019, Rule 38 as well as Rule 49 have been amended. In Rule 49, Subrule 2 of Rule 49 was substituted. Rule 38 and Rule 49 were amended, whereby Subrule 1 and Subrule 2 of Rule 38 were substituted. In terms with the said substituted, Subrule 2 of Rule 38 and more particularly the proviso to Rule sub-rule 2 of Rule 38, the requirement of having 10 years of qualifying service have been dispensed with, but have been made subject to the conditions stipulated in A and B. On the basis of the said amendment made to Rule 38 and 49, the Office Memorandum dated 12/2/2019 have been issued. This court have also duly taken note of that in the amendment so carried out, it was specifically stipulated that the said amendment would come into force on the date of publication in the official gazette, meaning thereby that the said amendment to Rule 38 and 49 has to be applied prospectively. The consequential effect, therefore, is that the Office Memorandum dated 12/2/2019 or even the amended Rule 38 and 49 cannot be applied. This court further finds it relevant to take note of a judgment of the Supreme Court in the case of Union of India and others versus Rakesh Kumar, reported in 2001 4 SCC 309, wherein at paragraph number 21, it was categorically observed that no person can claim any right on the basis of wherein it was on paragraph number 21, it was categorically observed that if the rules are not providing for grant of pensionary benefits, it is for the authority to decide and frame appropriate rules, but the court cannot direct payment of pension on the ground of the so-called hardship likely to be caused to a person who have resigned without completing the qualifying service for getting pensionary benefits. It was also observed that the pensionary benefits are granted to government servant who is required to retire on his attaining the age of compulsory retirement, except in those cases where there are special provisions. The same paragraph 21 being relevant is quoted here in under. In the backdrop of the above analysis, if this court duly takes note of the facts, it would be seen that the petitioner herein on his own account applied for the invalid pension, and thereupon he was discharged from his service. The petitioner did not have the qualifying service to be entitled to the service pension or the service benefits. Further to that, neither the amendment made to Rule 38 or 49 can be applied to the case of the petitioner, as the said amendment has been in the amendments are prospective in nature. Consequently, the Office Memorandum dated 12/2/2019 cannot be applied to the case of the petitioner. Under such circumstances, this court therefore is of the unhesitant opinion that the petitioner hearing is not entitled to a writ as sought for which the writ petition stands dismissed.
For hearing from the supplementary court, please. Item number 69.
Yes, Mr. Counsel, your matter. The other one, 67,500. Cost. Huh? No, that one, where you are asking for 75 after 1975. This is the matter.
Lordship, in this case.
Yes.
In this case, I would like to submit only two lines. One, Lordship. See, Lordship, in the state of Nagaland, our forefathers, we keep the land free of cost with a prospective motive that we will get some facilities like for trade appointment or something.
What you are going to get?
Some facilities like some appointment, for trade appointment and some kind of contract facilities.
Contract?
Yes, some contract. On that assumption, we are donating the land.
So therefore, there are two presumptions. No, therefore, from
Yes.
your submission,
Yes.
you give it free of cost, which takes it outside the scope of getting compensation. The second is you give it with a view, which is the Naga custom of here, that you will be granted some appointment out there.
And that is the precedent, and then that is the practice in Nagaland Lordship. Accordingly, the landowners were given facilities of appointment. Or
So,
some
Mr. Counsel, let me do one thing.
Lordship.
You can't get the relief which has been given out here.
Lordship.
Because you admittedly you have given it free of cost, and that is your representation also.
Lordship.
Now, therefore, if you are entitled to anything, there has to be a written agreement or an oral agreement. Written agreement is not there.
Not there.
So, oral agreement, if it is there, prove it before the deputy commission, and thereupon us. That is the only way.
That is why I'm just wanted to make simple submission that see, till now the land was not compensated, nor any facility.
Where is the question of compensation?
No facilities was given to me, whereas the other landowners, they were given appointment.
So,
And
under
then-
such circumstances, did you ever apply for a job?
Lordship, that see, appointment is made for usually for 30 years. So when initially they were given, the other parties were given, and then I was not given. And then when I at that point of time, we were not-
Because Nagaland government also has in that particular clause 3C
yes,
of that notification of 5/3/2018 that this right would not be in perpetuity.
Lordship,
Meaning
Lordship,
thereby
Lordship.
that you may not get, your son may get, avail the remedy.
That is well, Lordship. This land is a owner of combination of different landowners. So I'm also a part of. I'm also one of the landowners. And then I was not given. That is why, Lordship. Till now, my generation were not.
Now,
given
what
the-
do you want? Dismissal? Or what? With the cost of 767. Nah? I calculated wrongly. It 12 dates, 5,000, 60,000, 7,500 is for the effort. Cost of 67.
Lordship, my humble submission, if the petition is dismissed and with the cost,
Of
my
67,000.
plan would suffer immensely, Lordship. That is my humble submission. And then see, Lordship, till now, not that a single opportunity was given to me, Lordship. And then till
No,
now,
I think better off, you take up your things and say that you have an oral agreement and thereupon prove it on the basis of witnesses and all. and then they will apply and go there, because it is not in perpetuity. Nobody gets a job in perpetuity. So if somebody else has got any job, next time you will get. Maybe you may not get this time. Your son may get. Your son's sons may get. But you have to prove it, isn't it? What do you say?
Yes, my lord, here the petitioner, produce that there is written.
Withdraw, yeah, I better, you see, if I have to dismiss it, I'll have to hold, you cannot. So under such circumstances, let me pass the order allowing you to withdraw, and thereby giving you the liberty to approach the deputy commissioner, showing in terms with claiming rights under 5(3). That is the better option. What do you say? That is a better option for him. Why he wants to fight when he's going to get a dismissal, that too with the cost of 67,000? The learned counsel appearing on behalf of the petitioner submitted that, taking into account that the land was donated free of cost with on the basis of an oral agreement, that the oral agreement with the agents of the government, that the family of the petitioner would be duly granted an appointment as per the customs which is duly followed. And further, in view of the notification dated 5/3/2018 issued by the Chief Secretary to the Government of Assam, Land and Revenue, Government of Nagaland, Land and Revenue Department, he would not like to press the instant petition, but rather avail his remedies in terms with clause 3B of the said notification dated 5/3/2018. Considering the above, the instant petition stands closed. Stands closed. The withdrawal of the instant petition shall not, however, affect the petitioner right to claim remedies on the basis of clause 3B of the notification dated 5/3/2018, if otherwise permissible under the law.
for hearing item number 45.
Yes, tell me. Homeguard.
All the issue. How do I address it? The person holding the similar posts. Then is- Petitioner entered into service. And on 24.
You entered into service in what?
As Jamadar.
As Jamadar.
Jamadar.
2003. 2000.
Page 26.
26.
Yes.
Yes.
Page is the type of the worship. This order dated to be 5 July 2000. That is-
Okay. This is on 25/7/2020. And 2000.
Then next page, worship.
Yes.
By this order dated 10th 2006. Petitioner must given permission to the post of
He is the private respondent. Venka Konek. Twenty-seven.
27 is the additional of
27 is the type copy.
that code.
28 is
Motion order.
Subedar. So 10th of February, you are Subedar. Then
Page 30. By this order, lordship, is a command order. By this command order, there is command. With the post of civilian meeting. By order that worship to the 4th.
and number 1 is the private respondent.
Private respondent.
He is also promoted to the post of Subedar Major.
Yes.
Okay. Then
And the same thing, lordship. Next speech. Speech 31.
yes.
This is the list. Of civilian media. In my. Which we kindly turn to this list. Page 23. Serial number 7 is the petitioner. On the third column, motion. Get up training. Get up. Get up. Bring to service. Column number 2. Column number 4 was get up training in the government service. And the speaker petitioner was it is 27/7/2000. Column number 8 is the private respondent number 7.
So he was in 2001, date of joining. Then, so you are assailing this.
Yes.
You have been put at number, you are number 7, tentative seniority list, you are above. Then what happened?
All of a sudden, page 24. Page.
He was promoted. Without taking your consideration that you are number 7. That's your case.
About the petitioner, file an RDI. This is number 7.
So here in this promotional order, 1, 2 were given promotion from the tentative seniority list. Kindly come to page 33.
Page 33 was
1 and 2 were given the promotion.
yes.
E. Taiwan and L.
Yes.
John.
Yes.
And then I think 3,
Number
4, this was given in 2021. So 3, 4 must have retired.
I don't know.
And
I thought
5
it is-
and 5 was there. 5 was not taken into consideration. And 6 was also not taken into consideration. You are 7.
I'm sorry.
And 8 was given. That is your case. Now, as per what is the basis on which the promotion is given?
Lordship, you kindly turn to page 39. This is the information furnished to the RDA. Next page 40. This is the recommendation of the Department of Promotion. Very close.
No, it's okay. But what is the basis on which it is being done?
Basis, what do you mean? Kindly see the basis. Page 40.
Yes.
The Department of second paragraph, Lordship, the Department of Promotion Gauhati. Second paragraph.
No. What is the basis? Is it seniority come merit, merit come seniority, or what is it? Huh?
Seniority.
Seniority. Where is your guidelines? I mean,
There
the
is no
rules.
service no Lordship, friend of
Rules?
the- there is no service no friend of the article.
So there is no 309.
Basis of law will apply.
So what is are there any executive instructions? Then what is the basis
Oh,
you are
the
saying?
condition of seniority, Lordship, is seniority. But the basis of the combination of the case of the primary response is basis. Second is after producing this, what is can you turn to page 41? But then the seniority was discovered actually after the promotion of the previous.
Where he was made as number 7.
Page 42, Lordship. Yes. Student number 7 was let's give it a read. Lordship, you kindly see 5th column, Lordship. Date of last promotion to and the date of joining. Serial number 7, Lordship. 25/10/2016. And in speak of serial number 8 of Mr. Petitioner. 26/10/2016. This date, Lordship, I valid affidavit by the respondents. They have considered the date of filling into the promoted post for consideration. Petitioner and the web response of that. It is the case of the respondent that respondent submitted training report on 25/10/2016. Whereas the written petitioner submitted only on 26. That's outdated by the respondent. That is the basis condition of security. Therefore, my question was, before this report is how the agency seniority among the person holding the same post and the same letters should be.
You see, in the affidavit, they have enclosed the Nagaland Village Guards Gazetted Rules 2014. So there it says the method of recruitment through promotion, because here they don't include, these are the Subedar or Subedar majors are non-gazetted. So gazetted post will start from assistant commander.
Yes, sir.
And number clause, rule 5 says that all 5(2), yes, recruitment to 60% of the post of Group A junior will be by promotion from amongst the members of the Nagaland Village Guard Service, non-gazetted, holding post in the rank of Subedar Major DG. All the posts in Group A of these rules shall be filled by promotion from amongst the members of the Iman. A confirmed member of so-and-so shall be eligible for promotion, but no one shall be promoted unless he has served in the Group A post for a minimum of 5 years and the governor is satisfied of his ability, integrity, and character. Then kindly come to departmental promotion, 7 Roman 3. The selection shall be based on seniority with due regard to merit and suitability. The number of vacancies to which the promotion are to be considered shall be determined, and the head of the department shall furnish the following particulars. So on the basis that you have joined later in the post of Subedar Major, although your promotion was on the same day, they have made you number 8, whereas the other person was made 7. That is the case. So what is the basis on which the seniority is to be made in terms of the non-gazetted post? It is based on joining, or is
No,
it based?
no. What you can do? This one, in my affidavit reply. I will file the 4, 5, and 6. Page 7. This is number 96966. I'm touching with the promoted session. Bar 3. The related seniority of person promoted to various grades shall be determined in order of their selection of such promotion. This shall apply to cases where promotion is made by selection by academic and the seniority shall be in the order in which they are recommended for promotion by the government. Promotion was made to the
and the seniority shall be in the order in which they are recommended for promotion by the departmental promotion committee. So in the departmental promotion committee, you were higher, you were lower.
No, promotion order, which I referred. Promotion order, which
Page 30.
Yes. In pursuant of the recommendation of the Development Promotion Committee 27/2016. Recommended on the same.
Now, understood. But if we apply what you have stated in your affidavit in reply, then it in the order of this order, the respondent number 7 comes on top of you. Kindly see page 30 of your petition.
Is that a seniority?
Huh?
Is that a seniority?
No. Kindly see, now read this page, paragraph number 5 of your affidavit in reply.
Yes.
You have quoted rule 3.1 of the memorandum dated 9/6/96. It says, the relative seniority of a person promoted to various cadres shall be determined in order of their selection for such promotion. This shall apply to cases in promotion is made by selection by a departmental promotion committee, and the seniority shall be in the order in which they are recommended for promotion by the departmental promotion committee.
This is not, this is the promotion of page 30.
And where is the recommendation of? Huh? No, recommendation, there has to be a recommendation if you are taking it.
But Lordship, before,
because if we apply rule 3.1 of that office memorandum and close as a X.
Before this promotion order was issued, Lordship have already said that it is relative seniority. Page 33.
So then also you are senior.
Yes. What basis can your seniority is? Can you see is the relative seniority list dated 4/8/2015. Mr. What?
No, this is page 33 is for Subida measures.
Yes, sir.
Now these are two things. One is this one which you are bringing, page 33. This is on 15/9. This is the same thing. Why there are two seniority lists of the same date?
No, this
One is one. There must be some mistake.
No, this seniority list was published to this number.
No. Page 33 and page 42 is of the same thing. Tentative seniority list of Subedar under BG organization as on 15/9/2000.
Because this is the basis.
Now something must be wrong in both, because on the same date, why the additional deputy commissioner headquarters have signed both the documents? Yes, government. What is this document? Why there are difference? No, not that. In his writ petition, kindly come to page 33 and page 42. Why the same officer of the same seniority list prepared two seniority lists? It's the same date. 15/9/2018.
Page 51.
No, not page 41, page 42. It is all
My
15.
lord, the page number 42 is a rectified seniority list.
When was it made?
Was in that page number 33 was this was tentative seniority list was published, and
this is also tentative.
Yes, opportunity was given to the employees to, if there is any complaint or any rectification.
So what is the date of 33 and 42? There is no date. Only date is as
No,
on
my lord,
15/9/2000.
notification. Notification, my lord, that this is the governing letter, page number 41. This is the governing letter.
Is that?
Governing letter. Memorandum issued by, it was issued on 30/11/2018.
30/11, and the earlier one was
Earlier one was issued on 14
14,
September
14/9.
14, yes, 14/9/2018.
On 14/9, then it was done on 30/11. So that was the seniority list was prepared
Yes,
on the basis of the date of joining.
yes.
Now, whether date of joining is relevant,
My lord, earlier the lordship had rightly pointed out that as per for the determination of seniority list, in the office memorandum is very clear. It is counted from the date of recommended by the DPC. So, my lord, as per the DPC recommendation, private respondent is the senior to the petition.
but he says that this is not a recommendation. This is not a recommendation. This is an order.
I see that affidavit filed by a private respondent number 7.
Yes.
Page number 34. List of officers or staff in the promotion zone in order of seniority. This is the list placed before the DPC manual.
Where is the recommendation? This is a recommendation. This can't be the recommendation.
This is the service particulars. Service to the government. Pushing to the system. That is good.
Page 34, my lord, page 30. See the page 30. That is the proposal. And it's a 8. It's number 30.
Annexure
Next 8, page number 30.
of the
Affidavit in opposition filed by respondent side.
proposal for promotion. No, this is a proposal.
Yes, my lord.
Where is the
So, my lord,
recommendation?
first, my lord, this proposal will send to the DPC.
Read this. In continuation of department, I am directed to forward herewith the requisition for departmental promotion duly filled for promotion of the vacant post of assistant commandant under so and so along with necessary. So he has already proposed. What
Yes.
is the recommendation has to be on the basis of the recommendation.
Yes.
The recommendation has to be made. Where is the recommendation of the DPC?
The recommendation, my lord.
There is no recommendation of the DPC here. The DPC will recommend.
Page number 40, my lord. This is the order. Lord, page number 40.
This is a different thing. This is of
Yes, my lord.
2019. This is a different thing. This is the deputy, he is a deputy commandant, VG, Chief Ray, are hereby declared confirmed in so and so. This is confirmation. And why was the petitioner's ACR not taken into consideration?
My lord.
Page 38.
Yes, my lord. Notice has been given to the petitioner to produce the above. But the petitioner has not submitted. No, no, sir. No, my lord, notification is here, that order. My lord, on first for 2021.
This apologies remains with whom? The petitioners?
Yes, my lord.
With
through
the parties?
Through the commandant VG, that is the deputy commissioner. This letter was issued notifying the.
To the commandant VG and the deputy commandant VG. Now they have not produced. What will the petitioner do?
So notice was issued to produce the apart. but the petitioner has not submitted. But the remaining, the other,
Mr. Counsel,
yes, my lord,
this notice is given to whom?
to the deputy commissioner.
The deputy commandant and the commandant.
Commandant
Is the
VG.
petitioner the commandant or the deputy
No,
commandant?
he is under deputy commissioner VG.
So how, you have not given a notice to the petitioner to produce? You have asked the commandant or the deputy commandant to.
Same letter was issued to the other, and other they have produced.
Other commandants are
Except the
very,
petitioner, my lord.
other commandant and deputy commandants are very good people. Here, this person may not be good. They have not produced what to do. But how can you incorporate that there is a culpability on the part of the petitioner? Where is the recommendation of the DPC? In order to incorporate 3.1, then we have to have the recommendation from the DPC. You produce the DPC. Mr. Counsel,
Yes, my lord.
you produce the records.
Okay.
When? Next Monday, 2 o'clock. Next Monday, 2 o'clock. Records only.
And Friday, this Friday.
Okay, Friday. This is the matter on Friday at 2 p.m. No further hearing. In the principal seat, I don't fix at 2 p.m. So these matters, some lawyers who takes unnecessary time in the matters, I fix it at 4:15. And some which are absolutely useless, but the lawyers want to argue, I fix it at 4:30. So that they, without spoiling the time of the other judicial officers, the other lawyers, so let them argue. So it is between him and me. The other lawyers are not disturbed.
Yes. Much over.
For hearing item numbers 46 to 65.
Yes. G5 altered. Yes. Understood. We'll have it on Thursday. Don't worry. Your anxiety is about the respondent, isn't it? You are the respondent. Anyways, you are whatever submission is for the respondent. I'll take care of that. Don't worry. Let Mr. Joshua first satisfy that I need to hear you.
Please, Your Lordship. There are two batches of petitions here. One is the graduate teachers, and the other is the primary teachers. Lordship, both the graduate as well as the primary teachers, they were appointed as state cadre, as state employees, but their salaries were earlier paid under the RMSA, SSA RMSA. Your Lordship, there were some proceedings also before this on the court. The judgments which are annexed with the petition. The state respondents, they have made a categorical statement in the affidavit as well as in the submission before the Zound Court, which is reflected in the judgment and orders, that the 2010 and 2013 batch, who are the petitioners before the Zound Court in this case, they are state employees. Your Lordship, after the same has already been adjudicated by the Zound Court, now they have turned around to state that we are now streamlined as fresh state employees, Lordship. Now, if my Lord may kindly appreciate it, amounts not only to contempt but perjury also, Lordship. We find such an affidavit. Lordship.
So you want that person who filed the affidavit be called to the court?
Lordship, I do not
And
want
then
to insist to that
initiate
extent,
proceedings under 340?
Lordship, I do not want to insist on that, but it's unfortunate that the state has.
So
to-
your basic case is the respondents out here had categorically made submissions and on the basis thereof the court had passed orders.
Yes, Lordship.
And after the orders have been being passed, now they're making a somersault
Yes.
and saying that no, nothing doing,
Yes, Lordship.
without challenging that order.
My lord. Lordship, the 2010 batch, they were included in the 2015 seniority list also. Lordship. There, several litigations were filed against the 2015 seniority list. My lord, in the 2015 seniority list, those who came through backdoor, their seniority was given.
Let us see the judgment of this court. Where is it?
Yes, Lordship. May I take a Lordship to read petition number 311, 2022 for a graduate teacher?
Not 299.
Yes, Lordship, 311. That is for a graduate teacher's Lordship. 311. May I first take a Lordship to page 476, that is annexure 127.
Just 1 minute.
Hello.
Page
Lordship, 476, annexure 127.
476.
Yes, Lordship. May I take a Lordship to the operative portion?
No. Page, which page you are referring to?
476, 476.
The long judgment.
Yes, Lordship. If I may take a Lordship to the operative portion at page 522, paragraph 3. Lordship. This is a judgment dated 25/2020, Lordship. The paragraph 3 at page 522. The learned senior additional advocate general, Mr. K. Sima, submitted that it is true that the petitioners were appointed as per the advertisement. These are the other groups, Lordship. Dated 14/12/2013 on contract basis under RMSA scheme with appointment orders issued by the mission director of RMSA, but they were not appointed against the substantive post in the school education department of the state of Nagaland. Therefore, they cannot ask for parity in service condition with those who were appointed as per the advertisement dated 9/12/2011. This is the 2013 batch, Lordship.
9/12/2011 is different. We are concerned here with whom?
We are the 2013 batch, Lordship. These are the 2015 batch who challenged the state respondents to state that they are also
You
state
were
employees, Lordship.
appointed as per 9/12/2011.
Yes, we are the 2013 batch, Lordship.
You were appointed as per 9 to 9.
That is the advertisement date,
2011 advertisement.
Yes, Lordship.
Whereas the 15 batch was appointed on the basis of 14/12/2013.
Yes, Lordship.
Okay, then.
So this is concerning the 2013 batch. There are two batches, 2010 and 2013. So the advertisement dated 9.
Then what happened? What did the court say? Yes, where? What is the findings?
So, Lordship, this is with regard to their salary component, Lordship. Their salary were not equal to the salaries of the 2010 and 13 batch who are before the zoning court. So here, Lordship, when the 2015 batch, they tried to claim parity with the 2010 and 13 batches, Lordship. The state made a categorical statement that the 2011 batch, those who were appointed pursuant to the advertisement dated 9/12/2011, they are known as the 2013
So
batch.
these 335% who approached in that judgment given by Justice Sato were appointed pursuant to an advertisement on 14/12/2013.
Yes, Lordship.
And what was their grievance out there?
Their grievance was that their salary.
Was-
Their salary should also be equivalent to the salaries paid to the 2010 and 13 batch, Lordship.
So you were being paid 31,315.
Our salary, Lordship, as far as the amount is concerned, I cannot know, Lordship.
No, you have to know that.
No,
Because
Lordship.
if you are equating, saying that these people very well, we're getting all these people were getting there, and it is the specific stand of the state in that proceedings that you were regularly appointed by the government, whereas those people were appointed on contract basis, and the petitioner therein were asking for amount of 31,315, and you want that these whatever submissions have been made has to be equated to you, and said that the respondents have already stated that, and how can now they turn around? Then you have to show before this
Lordship.
court.
By this judgment, what I'm trying to show before you, Lordship, is that from day one, the state has been treating the 2010 and 13 batch as the state employees. By the advertisement, on the basis of the advertisement issued by the state, the posts were created by the state, Lordship.
Now what they are trying to do?
Now, they are saying that we were not part of the state employees, and then we are streamlined the state cadre only with effect from 21/4/2022, Lordship. That is the grievance, Lordship.
Then,
by then
in that regard, we are to see how you were appointed.
Yes, Lordship.
Let us see.
Yes, Lordship.
Where is the advertisement?
Page 59, Lordship.
Applications are invited from indigenous inhabitants of the state for filling up details of basic by notification. Scale of pay, scale of pay, then information under the will be published shortly for the post vacancy for which then declaration of the results. So all these people were brought in.
Yes, Lordship. This is a 2010 batch.
Then on recommendation of the district selection board, the appointment against the sanction post will be so and so.
Yes. Sanction post, it's my Lord, that's right. Yes, sir.
Oh, the pay and allowance of the appointees shall be borne by the state mission authority. What is that? State mission authority.
The state mission authority, Lordship, they get fund from the central, Lordship. So they were paid under the RMSA fund, Lordship.
So you were also paid?
Yes, because the state did not have the resource to pay. So it is a post created by the state. We were state employees from day one, Lordship, through a proper
But
advertisement.
Mr. Dosra,
Yes, Lord.
one thing I tell you, like the health mission or the education mission, Sarva Shiksha mission, the concept of payment has to be made on contractual basis normally. And the payment, if it is because the concept of regularization does not arise in SSA or RSA, RMSA.
Yes, Lordship.
The concept of regularization is not there.
True, Lordship.
Because they do not belong to the state cadre. But if the state had appointed on the basis of whatever may be, post has been there, why will the RMSA make payment?
Lordship, that is the arrangement of the state.
No. There's a reason why. The moment a post is being created for the state, it has a budget allocation. You cannot have any post. Look here, I want to have 10 more, here another 10 more peons in Gauhati High Court. No. These 10 peons have to be created by the state. And against that, fund has to be allocated. If the funds are not allocated, if the salary is not paid, how that you can say that this post they will get some money from some other persons.
The lordship is fully aware about the financial condition of the state of Nagaland.
Understood, but then
Yes,
also,
Lordship.
the state of Nagaland can borrow the money and then pay if they have their own post.
One issue which is very clear and the same cannot be disputed by the state respondent here. It's not suspension post created by the state of Nagaland.
Yes. Now what do you want? You want their seniority from there.
Yes,
Now what is the effect of having a seniority from there?
My lord, what is why, since we were appointed as state other, state employees, and of course, as far as the strange arrangement of the central scheme being made to meet our salaries, lordship, that is a strange arrangement, lordship. As my lord has rightly pointed out, they should have allocated the fund separately from.
They cannot have a post. They cannot create a post.
Even otherwise, my lord. Now, by 2015, we were included, 2010 batches were included in the seniority list. But we were also agreed by that seniority list, and we challenged the same before this own court, alongside other petitioners' lordship. The categories of the 2010 and 2013 batch also, we also challenged them. Then, this own court, in a similar case which is similar to ours, there was a judgment passed by this own court. Those who were appointed through backward and have to regularize and service procedure come from the date of their appointment. That way, our seniority was also protected, lordship. Our writ petition was also allowed by allowing the judgment to cover our judgment, lordship. And the same was agreed by the state respondents also, that our seniority should be protected. Now, when the new seniority list came out last year, lordship, our names are already excluded. And now we're trying to again take the excuse of streamlining us into the state cadre when we were part of the state cadre in the first place. Simple issue has been complicated by the state respondents.
Now, are you a part of the state cadre as of now or not?
We were from the beginning, lordship.
As of now, as per the respondents.
No, that is why, lordship. They are trying to streamline us into the state cadre.
They are trying or they have tried?
They have. With effect from 21/4/2022, lordship.
So from 21/4/2022, you want your seniority from 2015?
No, from the date we were appointed, lordship. The 2010 batch, 2013 batch. 2013, they are losing out 9 years. 2010, they are losing out 12 years of seniority.
So what is the effect of getting the seniority from then?
Lordship, only
because these type of arrangements must have been done for everybody.
Not for.
Because here the main problem, therefore, the moment I saw this appointment order, the payment is to be borne by the mission authority, state mission authority, SSA, which is obviously a central government.
Even otherwise, my lord is fully aware of the principle of law that when the fund is not attributed to the candidate, exceptional relief should be molded for the.
Now, in the advertisement, they mention who will pay the money. In the advertisement, did they mention who will pay the money?
No, in the advertisement, nothing specific is written.
Where is the annexure to this document? This is a very important document. Where can we get this government notification number ETS/SSA, the CPA/009/2008 dated 2010-2009? Where will we get this document? Because this document holds the key. Because they created the post. While creating the post, how did they create the post? They have to say out there that the amount will be deductible from this head of account. They have to do that. Without doing it, they cannot. This is how you create a post. While creating a post, you say that this amount will be debitable from this head of account. Where is this document? Page 59. There's a reference to these notifications.
Lordship, it should be with the state respondents. But as of now, what I wanted your lordship to kindly appreciate is that what before the single bench in another case, the 2015 bench, they tried to equate themselves with our group that is. Here the state has made a category submission before the zone court that the 2010 and 13 batch are state employees, state pattern, whereas they are employees appointed under the RMSA. So they cannot equate themselves with the 2010 and 13 batch. Submission is also reported by the judgment of this honorable court, both before the single bench as well as before the division bench.
Where is the division bench judgment?
Yes, Lord. 541, Lord.
Oh. Oh, this is, I was involved.
My lord.
Brother Urun.
Yes. This is the judgment of your lordship. Here at paragraph 9, my lord, 585, my lord. You take lordship to paragraph 9. There it is, my lord. 585.
Fact of sanction of the creation of the post by notification and the
The fact that the teachers appointed prior and subsequent to the petitioner under SSA and RMSA were treated as state patterns, living behind the petitioners by office members and so and so is not disputed by the state authorities. So by this, it means the 2010 and 13 batch lordship, the present petitioners. From day one, when we were treated as state cadres, can we be again freshly made into to streamline us into the state cadre once again? Lord?
So this judgment has been put to appeal in Supreme Court? 100%. If the Nagaland government needs, they should have.
This has not gone before the Honorable Supreme Court. Lord. And we have been treated as state cadre from day one. Now, can they appropriate and reprobate by turning around lordship 100 degree? Can they do that now?
Not 360.
360, we come back to square one, lordship. You know, this is the situation where our seniority needs to be protected, lordship. The only prize, or let's say the reward for.
Madam, you have not challenged the judgment? This on because this judgment have relevance because all these days everybody is mentioning about the Jagjit Singh judgment, and there is a matter pending before the SLP. Is this not the judgment? Because in view of I think this judgment is wrong. Though I am one of the co-authors, but this judgment is wrong in view of that. The second judgment, 2019 judgment, no? That judgment after Jagjit Singh. No, anyways.
In the first place, they are trying to bring us back into the streamline us again into state cadre lordship. Where is the wisdom in that exercise, lordship? When we are state cadre.
No, therefore we require that notification. This notification will clearly show as to how they created this post. Madam, you do one thing, I'm fixing it on Thursday. Now you get that notification.
I think it's connecting the.
Which one? In which case?
Yes, true.
Where is the counter? 3. Where? This notification is here? This is it. Yeah, you see, this is how it is done. The governor is pleased to accord the sanction of this post at the rate of a month. Expenditure is debitable. Here, you see? So, the state mission authorities shall deposit the requirement of the salaries for these teachers to the state government account through treasury salon quarterly on the basis of the availability appointed. After winding up of the SSA, the salary area shall have to be borne by the state government. So under such circumstances, this will be deemed to be an appointment made by the government.
Yes, my lord.
Because this is why I'm saying. So it is on the basis of that. Okay, we'll do it. We'll hear it on Thursday. That is, now we know what it is. Thursday or Friday? Thursday, I fixed another matter, that seniority list will. Yes, just now, there was another seniority list matter. 23rd is Friday. Okay, we'll have this on Thursday. So much of environmental.
My lord has already understood the case, so the files may look very fat, but should be a very short argument, my lord.
The point is otherwise simple.
Yes.
The point is out there whether you will be a state government employee from the date of your appointment or
Yes,
not.
my lord.
And once you are appointed, wouldn't you be appointed that the direct recruit's judgment would it be of any help?
My lord, there is another judgment for which I will take the lordship to the judgment on Thursday. Our seniority is to be protected. We have already approached this honorable court to protect our seniority. And our seniority is already protected by the judgment of this honorable court. It's part of this petition, lordship. I'll show you lordship on Thursday.
No, you want your seniority from your date of your appointment.
Exactly, lordship. And that has
So
already been
therefore,
delved into by this honorable court.
Therefore, whether the judgment, the constitution-based judgment in direct recruit will help you. 95 Supreme Court.
I'll have a look, lordship.
On the date of your substantive appointment, your appointment has to go back to that.
Lordship.
In this code, whether I would not disturb the others for another 10 minutes, prolong their journey back home. Yes, pass.
For hearing item number 66.
Yes, madam, when did you join? When were you appointed? 89? Have you completed 30 years? Huh? How? You were appointed on 1989?
Yes, madam.
Petitioner was appointed as workshop's labor on fixed pay. Was issued in favor of so and so. The demand was upgraded to Iman. What is the stand of the government?
The petitioner's case is under consideration. Her name has been put up for regularization.
When? Do we expect something good?
Your Lordship, that we cannot say, but since regularization is a lengthy process, the PNR has given its clearance.
This was done in September.
Yes, Your Lordship. Now it is with the Manpower Rationalization Commission. So after that, it will go to the cabinet for approval.
Another 3 months? You are the person who are informing.
Your Lordship, we do not know how long it will take at the cabinet.
Retired?
July.
You will retire in July. We have it then. This is an affidavit filed on 27th of September 2023. You have any further information as of now? What is your instructions, latest? Okay, we'll have it next week. We'll have it next week on 27th. We get an update. What is the status? Ms. So-and-so, the learned counsel appearing on behalf of the respondent submits that the petitioner's case for regularization in terms with the office memorandum dated 17/3/2015 is under active consideration. She submitted that as per her last instructions received at the time of filing of the affidavit in opposition, that is on 27/9/2023, the petitioner's application was under consideration before the rationalization of manpower committee, and thereupon the same was to be placed before the cabinet. She, however, submits that she has no instruction thereafter. Taking into account, so this court have also duly taken note of that that the petitioner is supposed to retire from service in the month of July 2024. Taking into account the above, this court fixes the matter on 29th of February 2024, on which day the learned counsel for the respondent shall apprise this court as to the present status of the petitioner's application being considered.
For hearing, item number 68.
Some other day. Okay, no problem. What is your case, by the way? Issue a direction to the respondent to settle the petitioner's late son's family pension and payment of pensionary benefit with interest. You have not been paid the pension. Normally, we take this pension matters with great urgency. In fact, if you see in the principal seat, there is a specific bench being created only for pension matters. Why this has been done? Because at the time when Justice Petition Singh was the Chief Justice acting, we requested him to have a specific pension bench, area salary, as well as transfer and suspension. Because these are matters of urgent nature. It shouldn't be lying out there in the last part of the bench, pension matter. Anyways, you want to do it some other time. When do you want it? Next week, you have seen so many matters are being fixed. Okay, the request of the learned counsel for the petition and matters is adjourned to be listed when? Tuesday. Okay, on 27/2/2024. The petitioner is given the liberty to mention the matter for upgrading. When am I fixing the other one, the seniority one? No. This Friday. So let's try it on Friday. Yes. This matter. You have an urgency or not? I'm giving you because it's a case of pension. If you don't have an urgency, this court is also doesn't have the urgency. There are too many matters left for me. Okay. Okay, Friday. Liberty is given to the petitioner to mention the matter of upgrading, taking into account that it's a pension matter.